All right, good afternoon. We want to welcome everybody. We're going to go ahead and get started. My name is Arvo Mikkonen. I'm the president of the Oklahoma Indian Bar Association. And we want to welcome you to our latest CLE entitled Jurisdiction in Indian Country post McGirt. This is for the practitioner. We're trying to focus on really nuts and bolts types of issues. Many of us have been following McGirt. We've been seeing the cases come out, and a lot of us have been consulted in connection with different issues that have been coming up in the past couple months since the Supreme Court decision. So we've assembled 4 speakers for you today, and we're going to be, this is being recorded. If you'd like to ask any questions, please do so by typing in the comments section, and then we will try to address those at the end. How we're going to break it up today, we're going to have our 4 speakers. Each one will present for about 45 minutes, and then that'll leave us some time at the conclusion to answer any questions that might come up. Although you're more than welcome to ask questions as we go, although it's a little disconcerting to try to monitor the questions and then answer them. But we have a couple of people that are going to be helping us keep track of all that. Some logistics. We are going to apply to the Oklahoma Bar Association for CLE credit today. So hopefully we'll get approved for 4 credits. We will be announcing 4 words, and Stephanie will pick our words for us, as she did last time. And you need to keep track of those, write them down. At the conclusion of the CLE, then you'll have an hour to send us those 4 words. And this is something the Bar Association requires in order to verify that you attended and listened to the entire presentation. So as we go, there will be 4 words which will be provided. And in addition to those 4 words, please, please, please include your bar number and your full name as it is registered with the Bar Association so that you can get the proper credit. We've had a few people, just in terms of logistics, if you are a paid member of the Oklahoma Indian Bar Association, if you paid within the past few days, then it's free for you. If you're not a paid member, then the cost is $75. We had some people sign up and they haven't paid their membership, so unfortunately we'll have to probably send you a bill, but if you get your payment or your membership in right away, hopefully we'll maybe we'll talk to the officers and see if we can grandfather you in and save you $25. I think that's most of the logistics that we have today. I'll go ahead and turn it over to Stephanie Hudson, who's with Oklahoma Indian Legal Services, and she's going to be doing the introductions for our speakers. One final thing, we will be uploading written materials to the Oklahoma Indian Legal Services website. So you will be able to download some of the PowerPoints and some of the other written materials that we're going to provide you this afternoon. So without further ado, we'll turn it over to Stephanie. And if you could introduce our panelists, we'll go ahead and get started.
Okay, thank you, Arvo. The first speaker that I would like to introduce this afternoon is Stacey Leeds. Stacey Leeds is an experienced leader in law, higher education, governance, and economic development. She serves as the Dean Emeritus and Professor of Law at the University of Arkansas. Dean Leeds was the 12th Dean of the University of Arkansas School of Law, becoming the first Indigenous woman to lead a law school. Under her leadership, Arkansas law reached historic heights and ranked 33rd among public law schools and was named the nation's #1 best value in legal education. During her time as dean, she was recognized as a national leader in diversity and inclusion and was the recipient of the American Bar Association's Spirit of Excellence Award. As a teacher and scholar of Indigenous law and policy, Leeds has served as the Salt River Pima Maricopa Indian Community Distinguishing Visiting Professor of Law at Arizona State University Sandra Day O'Connor School of Law, and she has also been the Director of Tribal Law and Government Center at the University of Kansas. She has also been the director of the Northern Plains Indian Law Center at the University of North Dakota, and she began her academic career as a William H. Hastie Fellow at the University of Wisconsin School of Law. Her most recent book, Mastering Indian Law, was published in 2019. Her new book, Cherokee Justice, Talton versus Mays, and the Revitalization of Tribal Courts, along with Professor Taiwagi Hilton, will be available in 2021. Leeds was the first woman to serve as a justice on the Cherokee Nation Supreme Court, and she is currently a district judge for the Muskogee Creek Nation and an appellate court judge for the Prairie Band Potawatomi Nation. She holds degrees from the University of Wisconsin and the University of Tulsa, and a business degree from the University of Tennessee, and an undergraduate degree in history from Washington University in St. Louis. And she's also an avid athlete and is in the City of Muskogee's Hall of Fame, Athlete Hall of Fame. So let me go ahead and spare no time and welcoming Dean Leeds. Thank you so much.
Thank you, Stephanie, for that introduction. And former athlete is the operative word. During COVID, I've done absolutely as little as possible. So what I'm going to start us off with, of course, a thank you to Arvo, as always, for getting us together. And I also want to give a special shout out to Joe Williams for helping us track all of these cases and stay on top of them. What I'm going to do today is kick us off with talking primarily about 4 cases that have been decided in Oklahoma courts post McGirt. And time permitting, I'm going to talk a little bit more about the mechanics of Indian land tenure in Eastern Oklahoma, because I do think that there are some potential nuances for civil jurisdiction that you may want to raise down the road or at least be thinking of. So I'm going to put those on your radar. But I know that by looking at the list of participants and knowing that you're turning into an advanced CLE on McGirt, we start, of course, with the presumption that you've read the case and you know the background there, and that you're actually practicing in this area, and you know that the Supreme Court provided clarity to its prior reservation cases. And at this point, when you count Murphy and McGirt, there's over 10 reservation boundary cases that have been heard now in the last 50 years. So there's a lot of Supreme Court analysis and conversation around this issue. Now, in those cases, the Supreme Court developed interpretive tests that apply to reservation boundaries. And this modern day question that came up in Murphy and McGirt as to whether the boundaries remain intact. And the Supreme Court has now concluded several times that even if lands inside those reservation boundaries have been allotted, and that they now include many non-Indians as the natural progression of the allotment process played out, that the boundaries can still survive. And, you know, those cases, of course, strengthened by McGirt, resolve any remaining ambiguity as to what it takes for a court to find disestablishment. And that's, of course, express language from Congress that the boundaries were intended to forever be disestablished and terminated or erased. And McGirt made it clear that the rule cannot be swallowed up by subjectivity anymore, right? Whether the court looks at a particular area and that the non-Indians in that area feel like it doesn't feel like a reservation anymore, right? And it puts aside the ability to take into consideration things that are outside of the text, right? And so outside of the text in those prior cases were things like what happened after allotment, what happened after the flood of additional people came in. And so we saw early cases where population density mattered. We saw early cases where the percentage of land and how it was held, trust land or restricted fee versus fee land, that could all play a role. So McGirt answered for us the question about Muskogee Creek Nation's reservation boundaries and provided this analysis that sharpens the textual limitations, right? That we look at the text of the boundaries and they are presumed to be intact unless Congress has taken some action, and that action has to be express and not inferred. So when McGirt was decided, there were several of these cases, as you all know, that were pending before the Oklahoma Court of Criminal Appeals after Murphy was decided in the 10th Circuit. And those were cases where defendants were seeking to have their convictions overturned. And there were about 40 cases that fell in that category. And those all got remanded down in August to the various Oklahoma district courts. And the remand asked two very clear questions. Number one, is this case a case that involves Indians? Most of the time that meant, is the defendant in this case an Indian? But we'll see in one of the cases that I'll talk about that it also can mean, were the victims in this case, did they hold the status of an Indian? And then second, did this crime occur inside of Indian country under the federal statute? And in all of these cases that we'll discuss today, that's 1151A. Is it a reservation boundary? And is that boundary still intact? Just like the McGirt decision. At the same time, in addition to those post-conviction cases that were on remand, there are many cases that are out there pending in district courts where the defendants have raised motion to dismiss for lack of jurisdiction following the McGirt decision. And all of these district courts have been entertaining what they're calling McGirt motions, or in some cases, depending on population, there's McGirt dockets where all of these are taking up, asking that same question. And so the cases that I'm going to talk about fall in those two camps. First, I'm going to talk about three cases that are decided now after those remands from the Oklahoma Court of Criminal Appeals. And the cases that I'm going to talk about there have decided that the Choctaw, Chickasaw, and Cherokee Nation reservations remain intact. And then I'm going to talk about just one of the cases from the McGirt motions that finds that the Seminole Nation reservation also remains intact. So if you take McGirt and then you add in these four cases that I'm going to talk about today, we now have affirmative rulings that all 5 tribes have intact reservations as far as the Indian country definition under 1151. So the first case I'm going to take up comes out of Pittsburgh County, and it's a case called Oklahoma versus Sizemore. And I'm going to give you the citations, but of course we'll post these on the website as well. But the Court of Criminal Appeals citation is F 2018, case number 1140, and then the local district court case number out of Pittsburgh County is 2016 593. And this case was just decided in the very end of October 28th, 2020. And an evidentiary hearing was held on the remand of that August order from the Court of Criminal Appeals. And consistent with what we'll see throughout all of the cases that I'll talk about today, the Choctaw Nation appears in that case as amicus, filing a brief on behalf of the nation. So if you're involved in these cases, there are exceptional briefs put together by all of the attorney generals of the 5 tribes. Reach out to them, get those briefs, because they will essentially lay out your case in each of these for you if you need to use those on the McGirt dockets in the local district courts. So in the Sizemore case, again, typical of what you find in the other cases, the court stipulated to a packet of materials that was presented that included treaties, agreements, maps of the reservation areas, allotment agreements. And the only thing in this case that the court did not agree to accept as part of the record was a couple of pages in the packet. So in that packet, they rejected the Indian country criminal chart that we're all familiar with, that Arvo shares and that many of us have used to teach Indian law. And the court also declined to accept as part of that packet a listing of the Choctaw Nation's various cross-deputization agreements that span a time frame from 1994 to present. In this case, Oklahoma appears to have just stood down in the case, not stipulating to all of the results, obviously, in the case, but not raising any arguments to the contrary. And so as to this first question about Indian status, the court answers this question And it involves the two-part test that's laid out in a case that I'll talk about in a little bit more detail, the 10th Circuit's decision in Diaz. And that's a case where it spells out a two-part test to answer the Indian status question. And so that is, does this person have Indian blood, some percentage of Indian blood, and does this person have recognition either from tribal membership or from the federal government as an Indian? And then as far as the Indian country inquiry, the court adopts this two-part test that says, first off, has a reservation been established in the first instance? Do we have a reservation at issue? And then as a second prong of that test or that inquiry, has there been a moment where you can point to text showing that Congress has in fact disestablished the reservation or not? So in this case, the court finds through stipulation of the parties based on a Choctaw CDIB card and a Choctaw Nation enrollment card that the Indian status is met. But the findings, I want to talk about what the court highlighted in the findings, because I know that this is coming up in other tribes besides the 5 tribes, and I want to try to highlight some of the operative language in these 4 cases. So first, the court spells out a pretty long dialogue about the pre-removal context as well as the Indian removal process specific to Choctaws. So the tribe or the court highlights the 1830 Treaty of Dancing Rabbit Creek, which it was important to this court that it spelled out precise boundaries. The court also made a lot of the fact that this was a fee title arrangement, much like the Muskogee Creek Nation and McGirt, and that there was specific treaty language that secured both jurisdiction and self-governance as it related to those boundaries. Also important was treaty language that suggests there's a promise never to move to another territory again and to never be embraced inside of a state or a territory. Now, I mentioned that because if you'll recall back to the riverbed cases, why Oklahoma is distinct and the 5 tribes, at least in eastern Oklahoma, are treated differently from tribes on other reservations has a lot to do with those promises coupled with the fact that the United States granted fee title. And I'll come back to that, but I want to put a pin in it. So the issuance by the United States of the fee patent in 1842, and then there are a couple of subsequent treaties that were important. First, an 1855 treaty that memorialized the separation of Chickasaw and Choctaw governments. And then the 1866 post-Civil War treaty, like the Muskogee Creek Nation, Choctaw Nation in that treaty is forced to cede or give up some areas of land, but that the reaffirmation of the reservation boundaries that are left, altered but still remain intact, was important for the court. And then also from the McGirt case, the court talks about in its findings this question about whether allotment can be read to be extinguishment of reservation boundaries. And the court references both the 1893 creation of the Dawes Commission for the 5 tribes, but also that 1900 commissioner's report, where it talks about how if the tribes would have ceded all their territory to the United States, this allotment process would be a lot easier, but they didn't, right? And the court recognizes that under a lot of pressure, Choctaw and Chickasaw finally agree to the Atoka Agreement, plus a 1902 supplement to that Atoka Agreement for the allotment process. But the court makes note that what's important about that allotment process is that it just discusses how the mechanics of allotment were to take place inside of the Choctaw Nation, but that there were never any land cessions to the United States, and that the allotment of lands and the holding back of some of those properties and making them not be part of the allotment process was critical to its finding. And so in the end, in this case, the court applying McGirt, but then specifically going through that legal and political history of the Choctaw Nation, finds that there's no disestablishment in the Choctaw Nation. And now that case goes back up to the Court of Criminal Appeals based on that decision. Next, I want to talk about a Craig County case. It also is an order on remand. And the name of this case is Oklahoma versus Hogner. And the case number at the district court level is CF 2015-263. And this is the case that is implicating the Cherokee Nation Reservation. And like the other case, Cherokee Nation's Attorney General Sarah Hill files amicus pleadings in this case and participates in that manner. And the state stipulates to both the Indian status and to the historical boundaries of the 14 counties. So what's left to decide after that stipulation is whether those 14 counties constitute a reservation that then has never been disestablished. And again, the operative treaty language in the Hogner case, it's highlighting the promise of a permanent homeland, forever set aside with a specific guarantee of self-governance tied to that territory and specific geographic distinctions for that jurisdiction. Also of importance is this fee patent, right? Executed in 1846, and similarly the 1866 treaty that, although the Cherokee Nation, like the other tribes, give up some land cessions post-Civil War, that land cession comes with reaffirmations of prior promises and boundaries that are just altered a little bit, but not taken away at that time. The one important thing I want to highlight about the Hogner case that I think everybody, as you're filing these, want to make sure to preserve is that the court here recognizes how the Cherokee Nation government themselves define their boundaries and their jurisdiction. Often in those pre-McGirt cases, when the court was looking at reservation boundaries and it was taking into consideration subjective nature, right? How the parties understood it at the time. A lot of those cases talk about how the state officials at that time understood it and that they started exercising jurisdiction. Rarely is there the citation to tribal government documents and how they, at the time and presently, define their own jurisdiction. So I think that it's really important, and so far it's the only state court case where I've seen this, is that, you know, it makes special note that the Cherokee Nation current modern government defines their boundaries and jurisdictions consistent with that land patent and with the treaties that I just mentioned. So that's a point to make in each of these. Also interesting from this case, the state of Oklahoma argues that the burden of proof should fall on the defendant to prove up the boundaries' existence. And the court punts on the burden of proof question by simply noting that Cherokee Nation and the defendants put forward a lot of legal and factual analysis that the boundaries are still intact and have never been disestablished. And Oklahoma did not submit into the record specific legal arguments that would refute that. And so the court, in finding that the Cherokee Nation reservation boundary remains intact, holds for another day this question about whether the burden shifts one way or the other. But I flagged that for you to clarify in your pleadings as well. The next case is the Oklahoma versus Bossy case, and that comes out of McLean County. And this one too is on an order for remand. And the case number at the district court level is CF 2010-213. This case involves the Chickasaw Nation, and like the other two cases, Chickasaw Nation appears as an amicus party in the case, filing amicus briefs. What differs from the other cases that I've talked about so far is that this is not a case where the defendant is Indian. It's a case where the victims in the crime, 3 Chickasaw citizens were the victims in this crime. And so it raises the federal jurisdiction as it relates to interracial crimes inside of Indian country. But still the same questions have to be resolved, and it shifts to the victims, but do they have the status legally as Indians? And so they apply the 2-part test. But the location where this crime took place is in Purcell, Oklahoma, inside the Chickasaw Nation's reservation boundaries. Now, McGirt, as you will remember, was limited to this question of Major Crimes Act jurisdiction and whether Oklahoma could hear crimes that took place inside the Creek Nation Reservation that would be Major Crimes Act federal prosecution. And what I think is important for all of us to remember here is that, yes, that's what McGirt says because it's that narrow application to the court. But what it really says is that Indian country status exists. And Indian country status is where the door is opened to the federal prosecution and the tribal prosecution, and where that door closes for state jurisdiction. And so it's a different federal statute, but the Indian country question is the same. What's also different about this case is a particularized finding that the court made. And I think that this is so important when we shift gears of thinking about criminal jurisdiction and talk later, if there's time permitting, about civil jurisdiction arguments. And specifically in the findings, the court noted that the chain of title for the land where this crime was committed originated in the tribe, and that the conveyance was from the tribe to the individual allottee in a 1905 allotment conveyance. And what was important for the court to note was that that conveyance never involved the state. If you take the chain of title from 1905, principal chief to the Indian allottee, and carry it all the way forward with all of the subsequent fee title holders, that the state of Oklahoma appears nowhere in that chain of title. And so it's a unique finding that we don't see in the other cases, but I think that it's a good one to continue pointing out. And when we have time, I'll come back to this, but I want to put that on your radar as well, so that you can continue to think about that. All right, finally, I want to shift gears to Oklahoma versus Barker case, and this is out of Seminole County. The local county case number for this is CF 2019-92. And unlike the first three cases that I mentioned, this case is not on remand from the Oklahoma Court of Criminal Appeals, but it instead arises on one of these McGirt motions, where the defendant raises motion to dismiss for lack of subject matter jurisdiction because it was an Indian defendant and the crime occurred inside of Indian country. Now, it is, like McGirt, a first-degree murder case. It's like McGirt in that it falls under the Major Crimes Act, the nature of the crime. And the defendant raises the issue alleging that it happened inside of the Seminole Nation boundaries. Again, like the other cases, and even on these McGirt dockets, the Seminole Nation appears filing an amicus brief. And there's an evidence packet that is submitted and not disputed by the state, taken into evidence by the court, that has the type of treaties and maps and agreements in terms of the allotment process that you would glean from the other cases. Now, in the Seminole case, the court says the reservation was established, goes into a lengthy discussion again about pre-removal and removal process, and talks about the 1833 treaty. And that is unique in that it labels, the court says, the Seminole Nation as a constituent part of the Creek Nation. And so there's a subsequent Creek treaty, in 1856, where it spells out that the Seminoles have their own distinct boundary. And then that's coupled again with a 1866 treaty that again redefines those boundaries. Now, I think of all of the 5 tribes, if we looked at the treaties and saw which one might be problematic, I think the Seminole one was deemed to be a little bit scarier than some of the others, because there's treaty language in Article 3 of that 1866 treaty where the tribe cedes and conveys to the United States their entire domain. And they are actually paid a lump sum amount for that amounted to about 15 cents on the acre, a little over $300,000. But there's a survival clause in that same treaty. And so the court makes note of Article 3 in that treaty that establishes a new treaty reservation boundary from lands that are acquired from the Creek Nation when they made land cessions immediately following the Civil War. And so there's sufficient language to establish reservation boundaries. And then the court ultimately concludes in this case that allotment and Oklahoma statehood does not do anything to take those away. But if you look on a continuum, the Seminole reservation boundaries would have been among the 5 the last to be established, and that they weren't established and preserved from removal to present, but in that later treaty. So finding that the 1866 treaty endures to the present, the court makes three very strong findings, and one of them I want to make sure that people continue to argue in these pleadings. First, the holding is that allotment did not diminish in any way or disestablish the treaty, that restrictions that were placed on tribal sovereignty over time did not diminish boundaries, that speaks to governing power but not boundaries. And then finally, they're very specific in this case to say that the state of Oklahoma's being did not diminish, and make a specific reference to the Enabling Act language when Oklahoma came into being. So those are the four cases that get us the rulings for the other four of the 5 tribes post McGirt. And I want to spend a little bit of time breaking down this Diaz two-part test when it comes to finding Indian status of an individual, whether that's the defendant or the victims in the case. And of course, you know, based on the language in the cases, this is that Indian blood plus test, right? That you have to show that there's some percentage of Indian blood plus tribal enrollment or federal recognition. And so as you would think here in Eastern Oklahoma, most people, of course, are just attaching a CDIB card and then tribal enrollment. But I want to talk a little bit about what the Diaz case actually says, because I do think that there's potential United States constitutional claims for equal protection if a case gets kicked out for someone not meeting the standard, if they're a member or citizen of a federally recognized tribe. So in the Diaz case, Diaz was clearly Indian. She was a tribal member of one of the pueblos in New Mexico, and she actually was a tribal official at the time. She served as their lieutenant governor for the pueblo. And she was charged in federal court for leaving the scene of a crime after hitting a pedestrian in her car. And she was convicted under 18 USC 1152, the one that speaks about interracial crimes, right? And so that 1152 statute extends the general laws of the United States into Indian country unless three different statutory exceptions are met. Right, so it statutorily exempts Indian on Indian crimes, and that's how we have misdemeanor claims that are exclusive tribal jurisdiction. And then it also exempts Indians who are punished by local laws of their tribe. So if it's these types of misdemeanor cases and the tribe prosecutes first, it's this statutory exemption that stops the subsequent federal prosecution. And then finally, the exception for treaty stipulations, exclusive jurisdiction for the tribe. And I want to highlight that because at least one of the 5 tribes has a treaty provision in their 1866 treaty that says that the tribe maintains exclusive jurisdiction over crimes that happen where all of the parties involved are tribal members. So for federal public defenders out there or people who are looking for that argument, take a look specifically at that treaty language and see if there's something there. So the crime that Diaz is charged with, they actually had to take New Mexico state law under the Assimilative Crimes Act to charge her with the fleeing a scene of a crime and then domesticate that into that federal prosecution. And she argued on appeal that it was never properly established that the victim was non-Indian, and that the only evidence of the victim's status was in the testimony of one person in the case, but that they didn't meet the burden to prove up non-Indian status. So that's where we get the test. It was not a test that was applied to whether the defendant was an Indian or not. But nonetheless, I want to flag this because I do think that there's a constitutional problem with this test. When it and similar cases have been applied, it tends to be that they get used in federal court to enlarge the body of people that the federal government could charge federally for crimes in Indian country to protect the public beyond who is a tribal citizen or a tribal member, right? And so I think in all of these cases, it has always been a given that if you're a tribal citizen, you're subject to federal jurisdiction. And the flip side, in the McGirt holding, I think that it's a given that if your tribe has made the determination that you're a citizen of that tribe, that should end the inquiry. And I think that state courts, if they're going to go down this path of subjectively saying, because of blood quantum, this person is Indian, but this other person, we don't feel like they're enough Indian, and that then would change status of tribal citizenship, that's a significant problem. We're told in cases like Morton versus Mancari that Indian is a legal political status and not a racial status. And that's how Congress has plenary power in this field. And so I see this coming up in a few of these lower McGirt dockets where that argument is presented. And, you know, it's certainly an open question if the US attorneys choose not to prosecute someone and the rationale is that that person isn't Indian enough, then I do think that it raises political dynamics between the tribe and the federal government as to whether the federal government is living up to its trust responsibility to keep Indian country safe or not. But I also, you know, grant that there's prosecutorial discretion about which crimes you move forward with and which ones you don't. What I'm more concerned about is the state of Oklahoma courts making a determination that someone who is a tribal member is not Indian enough to meet this standard. And that's where I think state decision-making process that is inconsistent or contrary to tribal determinations of tribal citizenship could be difficult. And so I flag that because I think where it's going to come up, if it hasn't already, is in the scenario of Cherokee freedmen citizens. And I'm limiting my discussion here just to Cherokee Nation and Cherokee citizenship. But under Cherokee Nation law and under federal law, pursuant to treaty language, Cherokee freedmen are full citizens of the Cherokee Nation, and they have the same rights and responsibilities of any other Cherokee citizen. And so I think this idea that they might not be prosecutable by the feds, or that Oklahoma would continue to prosecute them because there's a determination that they're not Indian when they have equal Cherokee citizenship rights, I think that's problematic. And I think that that's begging for an equal protection clause challenge, because that person's not being treated one way or the other because of citizenship. That then boils down to strictly a racial question. And I think that at least at Cherokee Nation, there's also the argument that there may be some citizens that were granted allotment and extended citizenship who were non-Indian back at the time of the Dawes Commission. And I don't think anyone wants to relitigate the Dawes Commission's work. We have our citizenship roles that the tribe relies on, and that's what should control moving forward. One other thing that I want to put on your radar, it sounds like in all of these district courts that these McGirt motions are going pretty smoothly, right? That defendants are raising the issue, the status is proven, the reservation boundaries are proven, and the courts at the local level are dismissing these cases. The only county that I have heard a different equation from is in McIntosh County. I know that there's at least one case where the state made the argument in a misdemeanor drug case involving an Indian inside of Indian country. And the argument was that that wouldn't have fallen under the Major Crimes Act because it's a lower level crime, and therefore McGirt doesn't apply. And so I don't know if that case will be appealed or not, but that really is the only instance that I'm hearing where a state court, at least in the preliminary ruling, is moving forward with a prosecution of an Indian person inside of Indian country, making that ruling that's a slight nuance from the McGirt decision. All right, it looks like I have maybe 5 more minutes. And so I want to throw one more piece out there to chew on, and we can pick it back up in questions after. But that's the question of Indian land tenure in Eastern Oklahoma and how it moved forward differently than the rest of Indian country across the United States. And it happens about the mechanisms or the mechanics of allotment itself. You know from all these cases that the tribes received fee land, and that fee land was then converted to allotments. And again, the grantor in that equation is the principal chief granting a fee patent to the Indian allottee. And then Congress comes in later and they add restrictions against alienation and different rules that apply to things that happen on that tract of land. So when that tract of land loses its restricted status, it's a piece of fee land now subject to ad valorem property taxes and other things, right? But the other things, I think, still have to be limited to the other things that Congress has specifically addressed. And so I'm going to ask you to put on the thinking cap about United States versus Montana and how the riverbeds in eastern Oklahoma were treated different than all the other riverbeds, because that fee title from principal chief to Indian allottee preserved a super Indian title, if you will, where the state of Oklahoma appears nowhere in the chain of title, and maybe no pure citizen of the state of Oklahoma appears in that title. And I say that from sitting where I am right now. I'm dialed in from Tahlequah, Oklahoma, and I'm on a piece of fee land that I purchased from another tribal citizen. And when I get the abstract back and I do the chain of title from the Cherokee Nation to the original allottee to present, I have to do a little bit more research, but by looking at the last names and the families that were involved, I'm pretty sure that the title to this tract of land is Cherokee Nation to Cherokee Nation citizen, and that continues on forward, and that there's no moment in time in that chain of title where that's not an Indian allotment owned by a Cherokee citizen. Now, it may or may not be in restricted status at varying different times. It could be placed back in trust where no trust has ever existed. But I want you to think about that and the case that I mentioned on remand from the Oklahoma Court of Criminal Appeals. When we get to civil jurisdiction discussions with Montana, if you have that tract of land like I just described, I think that introduces a new estate into federal Indian law, right? And that is, if you look at United States versus Montana, it says that where the tribe and its members no longer retain the right to exclude, then it's presumed the tribe lacks jurisdiction, but that could be revived through consensual relationships, health and welfare, etc. Right? Well, I think that just like the tribes had a stronger argument about reservation boundaries because that land was negotiated by our ancestors in fee, I think there's a much stronger argument that Cherokee Nation to Cherokee citizen to Cherokee citizen to Cherokee citizen equals land that the tribe and its members have never lost the right to exclude. And it creates this category that's somewhere in between trust land, and fee land that you would find elsewhere in Oklahoma. So when people say what percentage of the tract of land inside your reservation still is Indian country, I want all of us to stop saying it's about 2% because that's what is in trust or restricted status, right? It's bigger than that. And we don't know what that is because it would require these particularized chain of title inquiry into each conversation. But let's keep that as something to talk about because I do think that there's something there. And with that, I'm up until 1:47, so I am going to yield the floor back, and then I will be back at the end for any questions. Stephanie or Arvo?
Thank you, Dean Leeds. That was a very interesting presentation. I just texted my whole office and said, where's this super Indian land? So it's very fascinating. I love this. Okay, the first word that everybody can write down is Apache. Apache. That'll be the first word that you will write down, and at the end of this presentation, we're going to have you send your name, bar number, and all 4 words to the Oklahoma Indian Bar Association at yahoo.com. And we'll collect all of that and send those in to the Bar Association for CLE credit. Okay, it is 1:48 right now. Let's take a break. Let's come back at 1:55, and that'll give everybody a chance to take a break and grab something to drink, and then we'll come back at 1:55, and we'll have Arvo Mikkonen do a presentation. So we'll be right back. Okay, it is 1:55 and we're back. And our next presenter is Arvo Mikkonen, and he is an assistant U.S. attorney in the Office of the United States Attorney for the Western District of Oklahoma. He received his degree from Dartmouth College, and he graduated Phi Beta Kappa. He graduated with a JD from Yale Law School, and after graduating law school, Arvo served as a law clerk for Judge Lawrence Margolis of the U.S. Claims Court, and he also clerked with Judge Robert Parker with the United States District Court for the Eastern District of Texas. He has been a federal prosecutor since 1994 and has prosecuted cases involving violent crimes, physical and sexual assaults, homicides, firearms offenses, immigration offenses, as well as civil cases involving administrative law foreclosures and government regulations. He's been of counsel of record in over 500 cases in the U.S. District Court for the Western District of Oklahoma. He is a member of the Kiowa tribe and also of Comanche and Finnish descent. And I always love to tell about this, is he was also recognized in 2012 with the Attorney General's Award for Exceptional Service in Indian Country during the 60th Annual Attorney General's Award Ceremony, which recognizes both department employees and others for their outstanding dedication to carrying out the U.S. Department of Justice mission. Arvo is a wealth of information when it involves jurisdictional issues in Indian Country. And Arvo, I'll go ahead and turn it over to you.
Thank you, Stephanie. Again, my comments here today are those of my own. They don't really represent the position of the Department of Justice, U.S. Attorney's Office, or the United States government. I'm very glad to see so many participants that are moving forward with all of these unique arguments coming up with McGirt, and Stacy's presentation was very interesting. I was really fascinated by some of the concepts she brought up. And because we're focusing on kind of nuts and bolts issues here, I'm going to go over basic criminal jurisdiction and then talk about cross-deputization. Sometimes you see deputization. I like the Z in there. Sometimes you see it as cross-deputation. I think they're the same thing. And I do have some slides that I'm going to show you with my PowerPoint, and we're also going to have some materials that we will be providing for you to download off of the Oklahoma Indian Legal Services website probably early next week. So we've got a kind of a 2-page summary. I'm going to go over a lot of that information today. Again, if you have any questions about that, please put them in the chat. I'm going to go ahead and see if I can start my PowerPoint and hope everything goes well with that here. Just get that going. All right. All right. I'm going to kind of zip through some of this fairly quickly because I think a lot of you know a lot of these issues, but in case you don't, we want to make sure that we're all operating from the same perspective. Again, jurisdiction is determined by essentially 3 things: status of the land, whether or not it's Indian country, not status of the crime, whether or not it's a misdemeanor or a felony, and also the status of the person, whether or not they're Indian or non-Indian. And that can affect either a victim or a defendant. Here are the original reservations in Oklahoma. I think most of you know where the boundaries are at. Of course, the operative statute, which is at issue here, is 18 U.S. Code Section 1151, which is the definition of Indian country. And that defines the areas where there is state distinction from federal and tribal jurisdiction. Federal and tribal jurisdiction generally would apply within Indian country for our certain Indian country type statutes. And outside of Indian country, then the state would normally have jurisdiction. Okay, if you take a look at 18 U.S. Code Section 1151, there are 3 sections, A, B, and C. A includes both land within formal and informal reservations. In an informal reservation can be a tribal trust land property like a casino or a tribal headquarters. Dependent Indian communities, which are kind of a unique animal unto themselves, which are land set aside for exclusive use and occupancy of Indian people that is subject to federal superintendents. We have a couple of examples of that. In the Western District of Oklahoma, the Riverside Indian School has been recognized to be a dependent Indian community. Chilocco Indian School, actually, which is now in trust, but before it was put in trust, it was recognized as a dependent Indian community. And then the bulk of our property that we have in Oklahoma, of course, are the trust and restricted allotments. There's no distinction between a restricted allotment and a trust allotment. They're treated the same in terms of whether or not they're Indian country. Of course, most of the casinos are located on tribal land, which would be categorized as 1151A. You might not think of the Riverwind Casino as a reservation, but we treat it federally as 1151A land because it's not B and it's not C. It's essentially an informal reservation. Most tribal headquarters are also treated in the same way. They would be 1151A. The concept of an informal reservation comes from a couple of Supreme Court cases and 10th Circuit cases that essentially says that you don't have to have a formal designation of a property to be considered to be 1151A reservation land. Also, rights of way, roads, doesn't matter if it's a state road, federal highway, dirt road, any rights of way going through those lands are considered to still be Indian country. Dependent Indian communities, again, are defined pretty much by the Venati case. And that's a U.S. Supreme Court case that set forth the 2 parts of the formula, excuse me, that are Indian country, which include the federal superintendents and the set aside by the federal government for exclusive use of Indian people. Again, Indian allotments are include both trust and restricted allotments. So long as the restrictions and the trust status has not been extinguished or lifted. And that creates our checkerboard patterns that we see quite frequently in our jurisdiction. For example, this is an example of tribal property around Lawton, Oklahoma. That's a former Fort Sill Indians gold property in the green. And then you can see some in the yellow and orange. Those are tribal, actually tribal former allotments that are still held in trust. Same thing, this is around Carnegie, Oklahoma, and you can see there are quite a number of different parcels as you're driving down the road. And if we don't have boundaries, then we have to figure out whether or not the crime took place on one of those parcels. Most everybody knows that Oklahoma was opened by land runs and land lotteries, where non-Indians came in and took tribal reservation lands in various ways, either by staking a claim after a land run or receiving a chance to get a property pursuant to a lottery. So what happened essentially after the treaty-based reservations were opened up for allotments, and after allotments were made to tribal members prior to the opening, and those are reflected by these red squares here. And again, tribal allotments or tribal lands that were allotted essentially ended up in individual Indian ownership and were no longer owned essentially by the tribe. We do have some tribal trust lands that were either set aside for cemeteries or tribal use. And then we have some areas that were dependent Indian communities. This is an example of essentially what happened during the allotment of the Kiowa Comanche Apache Reservation. This was the third reservation that was established through various treaties. This reservation was established by the Treaty of Medicine Lodge in 1867 and was approximately 3 million acres. There were, and this is important in terms of, and I'm sure that Kirk will discuss some of this, in terms of figuring out not just the 5 tribes, but there are quite a number of other tribes in Oklahoma that certainly have arguments one way or the other whether or not they still have continuing reservation boundaries. And one has to look at the allotment agreements, the negotiations between the tribes, the enactments, how Congress treated the property at a later time. But this is essentially what happened with the Kiowa Comanche and Apache area. The allotments were made so small, 160 acres. And if you go back and do some of the research, there were even complaints back prior to allotment that one could not survive in Western Oklahoma on 160 acres, even raising cattle, because there's just not enough land that could be productive. Nonetheless, despite objections from tribal members and others, the allotments made for the Cheyenne Arapahoes and the Kiowas and Comanches and Apaches were limited to 160 acres. Well, if you do the math, the number of tribal members multiplied by 160 acres, you'll see very quickly that there was a reason that that was done, obviously, because when you do the math, the number of tribal members times 160 acres, it comes to about 2.5 million acres left over that was not assigned to any individual Indian. So after allotment, this is what essentially happened to the area. And you can see that the yellow and the red squares are the allotted lands. And then you can also see here that in this center area, some areas were reserved from allotment from the original allotment acts that were passed. For example, this is called the big pasture. There's some other areas over here which were grazing land, or wood lots, wood reserves. And so that's another important thing to look at in determining whether or not boundaries remain, if the entire area was opened or there were particular things that happened that were unique to that particular tribe. The important aspect of the Indian Country Statute is the quote, notwithstanding the issuance of any patent language in 1151A. And essentially what that means is when the reservation boundaries are there, then the entire square is considered to be Indian country. If the boundaries are not there, then the area is no longer considered to be Indian country, even though if the boundaries are there, even though the land is owned by non-Indians or the state, then it would still be considered to be Indian country. So, of course, that's what was at issue in the McGirt case, and that's what's remaining at issue in connection with those recognized boundaries of the Creek Nation and some of the other tribes, is what authority does the tribe have within the fee areas that are within the reservation boundaries, but are not owned by an individual Indian or owned by the tribe. Okay. This is the McGirt case, of course, which changed the landscape here in Oklahoma. And let's jump over that. As most of you had seen, the original boundaries superimposed today take up many, many counties in Oklahoma. And of course, that's the basis for us having this training today and recognizing the change that that has taken place with respect to the division of jurisdiction between state, federal, and tribal. Initially, there was some question about does it apply only to the 5 tribes? The McGirt decision, I think most legal scholars have looked at the issue and have concluded really it's a reservation disestablishment case. It's not really a question of something that's particularly unique to the 5 tribes. And included in the remands, the other cases that were pending in front of the Supreme Court, remands were also made from the Supreme Court to apply the McGirt reasoning to 2 other cases, one involving the Ottawas and one involving the Citizen Potawatomi, obviously, that are not one of the 5 tribes. It's actually fairly soon after the decision in McGirt, the 7th Circuit made a determination and utilized the reasoning in the McGirt case to find that the boundaries of the Oneida Nation in Wisconsin remained intact. So here's a map essentially of the tribal jurisdictional areas in Oklahoma, showing the tribal areas, the counties, and the 3 federal districts. Again, looking at some of the other tribes beyond the Creek Nation, each tribe's law and history will have to be analyzed, whether or not their boundaries continue to exist or whether or not the boundaries have been disestablished. For example, the Poncas and the Otos have very clear language that disestablished and erased their boundaries in their allotment agreements. Those are really the only 2 tribes in Oklahoma that have that type of language in their allotment agreements. So we look at tribal jurisdiction kind of in a unique way, but actually, you know, when I worked in the Eastern District of Texas, looking at some maps of some of the national forests down there, it was very interesting to me because usually when you look at a map of a national forest, you think that all of the land within the national forest is forest land. And here's some examples from the Sabine and Angelina National Forest. And you can see the boundary of the national forest is shown in black. The actual forest land that is owned by the Forest Service is the green. So there's a very large amount of the land within the national forest which aren't owned by the federal government. They're actually private landholders, state property. And so the concept that you have a boundary of a federal jurisdictional area and then the actual land ownership is a lot less within those boundaries is not something that's unique to Indian country. Here's another example of the LBJ National Grassland, which looks very large on a map here with the black boundary, but if you actually look at the grassland property, it's the dark brown shaded area, not very much of that entire property. Okay, we talked about who's an Indian. That's what we also have to figure out in order to determine whether or not we have jurisdiction. As most of us know, each tribe has its own definition. There are some questions that have come up recently, and I don't know that we've had any definitive answers in this area, but this is another food for thought type of thing. As questions have come up recently in determining whether or not somebody has to be enrolled as a tribal member at the time they committed the crime to be challenged. I don't know that there's clear authority one way or the other. It seems as though some cases say, some of the courts have come down and said, well, you had to be enrolled at the time you committed the crime. Other cases have said, no, you really don't. If you were, considered to be an Indian, then you don't actually have to be enrolled. Essentially, in the 10th Circuit, we have a two-part test. You have to have some Indian blood, and some government has to say that you're Indian, either the federal government or the tribal government. So if you're not enrolled, if you're receiving services from the federal government, like Indian Health Services from the Indian hospital, that can be an argument that one is still Indian, even though they're not enrolled, because one government, the federal government, has recognized them as being an Indian. Just for those people out there, again, the fact that you have Indian blood doesn't necessarily mean that you are a member of a tribe. So relying solely upon CDIB, certificate degrees of Indian blood, is not a good way to determine whether or not somebody is Indian or not. You really have to look to see whether or not the tribe considers them to be an Indian, or the federal government considers somebody to be an Indian. For example, here's a Choctaw tribal ID and a Kiowa tribal ID. And this is the kind of proof we look at in terms of prosecuting a case. You're trying to figure out who has jurisdiction by determining, does somebody have Indian blood, and does some government recognize that they're Indian? Okay, in 1978, after the Oliphant decision, generally tribes only had jurisdiction over misdemeanors involving Indians. And the Supreme Court determined that the federal government, that the tribal governments do not have jurisdiction over non-Indians. That's changed somewhat, and I'll touch upon that in just a little bit. Generally, tribal jurisdiction is going to be limited to misdemeanors by Indians when an Indian commits a victimless crime, an Indian versus a non-Indian crime, or an Indian versus an Indian crime. And of course, we have tribal court codes and the CFR, which is the Code of Federal Regulations, which is applied in the courts of Indian offenses, essentially primarily handling misdemeanor cases, although under the Tribal Law Enforcement Act, TLOA, Tribal Law and Order Act, a tribe can prosecute somebody for a felony crime, and the penalty can be up to 3 years, so long as constitutional guarantees are provided in the tribal court, and those can be stacked up to 9 years, although very few tribes actually do that because it's expensive to go through and incarcerate somebody for that period of time. Most of us know that there's an exception pursuant to a decision in 1881, where the US Supreme Court said a non-Indian versus a non-Indian crime is not subject to federal jurisdiction. And of course, it's not subject to tribal jurisdiction at the time either. And this is an exception to the general rule that a state does not have jurisdiction in Indian country unless Congress allows it. So under our current interpretation, a non-Indian who commits a crime within Indian country, if it's a non-Indian crime or non-Indian victimless crime, that would be exclusive state jurisdiction. One issue has come up in connection with non-Indian versus Indian crimes. And generally the rule is that a non-Indian versus an Indian crime is exclusive federal jurisdiction. It's not state jurisdiction. This is a matter that's now being litigated. It's been brought up several times in various cases in Oklahoma. Other state courts have looked at this issue in South Dakota, Arizona, Montana, North Dakota, and have come down with the same conclusion that a state does not have jurisdiction when it's a non-Indian versus Indian crime. That's exclusive federal. After the decision in the ex parte Crow Dog case, which said that the federal government didn't have jurisdiction over Indian versus Indian crime, that of course led to the Major Crimes Act. We have two major statutes that we rely upon in federal court to determine whether or not we charge a crime and what crime that we charge. Separate and apart from that, since a federal court is a court of limited jurisdiction, we only have authority to prosecute a crime if we have either a federal property involved, which could be a federal installation where we have exclusive jurisdiction, like in the Western District, we have portions of Tinker Air Force Base, portions of Fort Sill, portions of Vance Air Force Base, or Indian lands when an Indian is involved, either as a victim or an offender. The other category of cases are what we're calling cases of general applicability. In other words, cases that we get federal jurisdiction from as a result of somebody crossing a state line or as a result of somebody involving a federal interest, like an assault on a federal officer. For the crimes that occur on Indian country, we rely primarily on two statutes, the Major Crimes Act and the General Crimes Act. Major Crimes Act are crimes brought against Indians, and it can be an Indian versus Indian, Indian versus non-Indian, or under the General Crimes Act, we have a broader category, and that's either Indian versus non-Indian or non-Indian versus Indian. The Major Crimes Act limits us to certain types of offenses, and those are listed out in the Major Crimes Act. Here's the language of the Major Crimes Act, and it's been amended several times. You can see the categories of offenses that are listed there. And those are the bulk of the cases that we prosecute in federal court are Indian crimes committed by Indians against non-Indians or Indians versus Indian. These are the Major Crimes Act crimes. They're further defined by federal law. And in a couple of cases, we rely upon state definitions where we don't have a federal law that covers the particular offense at issue. We essentially what's called assimilate, or under Section 13 of the U.S. Code, we bring in state law depending upon where the Indian country property is located. When we charge somebody under the General Crimes Act, that gives us more offenses that we can charge. The Major Crimes Act has a listing of offenses that we can charge. The General Crimes Act, so if we have a non-Indian versus Indian or an Indian versus a non-Indian case, we have a lot more federal crimes that we can rely upon or utilize or would be applicable. And essentially, it makes the entire U.S. Code applicable to Indian country if we have a non-Indian versus Indian or an Indian versus a non-Indian crime. There are a couple of exceptions there. We cannot charge an Indian versus Indian crime under 1152. Also, if the tribe has already prosecuted somebody, they've already been punished, which is essentially if they've already been sentenced, then we cannot come in, even though it doesn't involve double jeopardy. We cannot come in after the fact. There's a statutory bar to prevent the federal government from prosecuting those cases. Like I said, essentially the General Crimes Act just makes Indian country like a federal enclave for those categories of cases that we just described. All right. If we have a choice between prosecuting under the Major Crimes Act or the General Crimes Act, then we have to bring it under the Major Crimes Act if it's an Indian versus a non-Indian, and that's generally what we do. Of course, because the tribe is a separate sovereign, we don't have problems with double jeopardy. If the tribe has prosecuted somebody, we can still come in and prosecute them federally. Or if the federal government has prosecuted somebody, they can still be prosecuted tribally. We also do have situations sometimes which comes up involving extradition, and we have to follow specific procedures in order to guarantee that state officials don't just go onto Indian land and arrest somebody and take them off. They have to follow the tribal extradition procedure. There's a modification I made fairly recently, actually probably within the past 6 months, to the Indian country jurisdiction chart that we've been circulating for, oh gosh, probably 10 or 15 years. There's another category of cases, and I want to always kind of highlight these because these are kind of unusual cases, and sometimes people overlook them because they really don't come up under 1153 or 1152, but they do apply within Indian country. And there's some special statutes, and I've modified the chart, and we will provide the chart that you can download. I've got a picture of it in this PowerPoint, but we'll also provide it to you. And if you want to go to the U.S. Attorney's Office Western District website, you can go there and you can download it as well. And these are these three offenses: habitual domestic violence, which is basically the third time somebody's committed domestic violence. If that takes place within Indian country, we can prosecute them. So if they have 2 prior state charges, 2 prior tribal domestic violence charges, 2 prior federal domestic violence charges, or just any combination thereof, if it happens within Indian country, doesn't matter if they're Indian, doesn't matter if they're non-Indian, we can charge them under 18 U.S. Code Section 117. Failure to register as a sex offender within Indian country is also a federal crime. Doesn't matter if you're Indian, doesn't matter if you're non-Indian. Unauthorized hunting and fishing is another thing that sometimes people overlook in connection with these essential federal statutes that are particular to Indian country. So this is a summary of victim crimes: tribal, local, and federal. Tribal, again, primarily Indians are prosecuted. Local crimes and state crimes, non-Indian versus non-Indian, go to the state. And just as I described, Indian versus Indian, we prosecute the major crimes federally. Indian versus non-Indian and non-Indian versus Indian under 1152, we prosecute those as well. Victimless crimes, again, those all are local, state crimes, only state jurisdiction. And then tribal and federal victimless crimes can be prosecuted depending upon the nature of the crime. This is the chart that I mentioned, and it's kind of too small to see here to go through, but you take a look at this chart, you can figure out very quickly who has jurisdiction if you know where the crime took place. Was it within Indian country or not? Was the victim or offender an Indian? And what was the crime? And again, originally we had a situation in after McBratney where we did not have jurisdiction under the tribe for offenses involving non-Indians, but as you can see here, there was an amendment made under the Violence Against Women Act, which allows for certain tribes to prosecute non-Indians for domestic violence, dating violence, or violation of protection order cases against non-Indians. Okay. Now, one of the things in determining cross-deputization is you've got to understand all of this jurisdictional information that we just provided to you. And it's important to remember, and sometimes we get law enforcement officers that get confused between state authority, tribal authority, and federal authority. And this chart, I've tried to lay it out in terms of just trying to keep track in our minds what officers have what authority. So as you can see here, a state officer will obviously have state authority. They don't have tribal authority. They don't have federal authority. They can get tribal authority if we get a cross-deputization agreement. A tribal officer, again, doesn't have state authority generally, but has tribal authority and does not have federal authority. A federal officer generally can be treated as having some state authority pursuant to this statute, just as a tribal officer can, but it's under limited circumstances. And there's a Oklahoma state statute 21 OS section 99A, which comes into play here, which shows you that if a federal officer is rendering assistance to a law enforcement officer in an emergency or to an assistant in arrest, then they can be treated as having state authority. Generally, a federal officer is not going to have tribal authority unless they have a tribal cross-deputization agreement. And this, of course, shows that they're federal authority. Now, one thing that's interesting under 21 OS 99A, a tribal officer can have state authority without having a cross-deputization agreement in place if this formula essentially applies. So if you look down here, there are 5 circumstances. If there's an emergency involving threat to life or property, if there's prior consent from the head of a state law enforcement agency, if it's in response to a request for assistance under a mutual assistance agreement, or in response to a request by another state peace officer, or if somebody's transporting a prisoner. If those 5 things are involved, then a tribal officer can be treated as a peace officer on Indian country or on tribal fee land. However, that only would apply if they've been CLEAT certified, which is Council on Law Enforcement and Training, which is a state agency, and have an SLEC, which we're going to talk about in a moment, which is a Special Law Enforcement Commission from the Bureau of Indian Affairs. So that's a lot of things to check off on the box to have a tribal officer have state authority. Okay, so just so that we understand kind of where each officer has authority already and where they can get authority in order to understand cross-deputization. Okay, again, because we have a, what's sometimes referred to as a crazy quilt of jurisdictions, allotments, and different tribes, and cities that straddle the line between different tribes and different counties and jurisdictions. Cross-deputization really is the solution to address these differences to make sure that an officer has the proper authority. Again, why is it that we want an officer to have this authority? Because we want an officer to be able to respond to crime and not have to worry about identifying land boundaries or whether or not somebody's Indian or not, or things like that, that you obviously can't tell when you're responding to a crime. Let's see here. It's also a force multiplier because it essentially allows for more law enforcement officers to be able to respond to crime when resources are stretched thin, or because we have an area that's very large and we don't have enough police out in the field. So essentially the goal of cross-deputization is to provide for state officer, ideally get tribal and federal authority, a tribal officer have state and federal authority, and a federal officer have state and tribal authority. So everybody has as much authority as possible. It prevents officers from having to determine jurisdiction as to whether or not they're on Indian country or not on Indian country, or whether or not somebody's Indian or not Indian. It protects the collection of evidence because we want to make sure that an officer that's collecting evidence is doing so properly, that they have the authority to collect evidence. We have to get a search warrant. We have to go to the proper court and figure out, who has jurisdiction. And actually, the process of cross-deputization does not involve an extra cost or expense for a police department. So that's another benefit. Now, years ago, there was a lot of problems in connection with cross-deputization because each jurisdiction was kind of making up their own cross-deputization agreement, and it became very complicated because we had so many different versions. The solution to that was to create one base agreement, and that was a base agreement that was established and approved in 2006, and that's the one that we're still utilizing today. And so that's a basic standard agreement that was approved by the Bureau of Indian Affairs, the Oklahoma Attorney General, the Governor's Office, the state legislature. And how these agreements are being executed now is basically relying upon that base agreement and then having addendums, having attachments which further clarify which jurisdiction applies to, which crimes are involved, which areas are involved, which agency is involved. And that way, it doesn't involve having to reinvent the wheel every time there's a different situation involving a particular jurisdiction or particular agreement between a tribe or a city or a county. The liability that's involved rests with the government under whose authority the officer was acting at the time. So that's one thing that's important. And what essentially happens is under the base agreement, most officers that utilize that process are able to get special law enforcement commissions from the Bureau of Indian Affairs. So in other words, a state officer is transformed into having additional authority that would be the same authority that a Bureau of Indian Affairs Department of Interior officer would have. And that's for a 5-year term. So it essentially, once a state officer or a county officer or a tribal officer gets this SLEC, they are a federal officer when they're acting in the capacity of responding to a crime that's in Indian country. Now they're not a federal officer just like an FBI agent or an ATF agent or Secret Service. They're limited to Indian country. Now, generally, when an addendum is made, in order for that officer that has an SLEC to enforce tribal law, there has to be an additional approval by the tribe to allow that officer to exercise tribal law in addition to federal law, because an SLEC is only giving jurisdiction or only giving authority to the officer when they are enforcing federal law. It's worked very successfully in Oklahoma. Many years of cooperative agreements have been in place. However, there are a lot of areas still that don't have cross-deputization agreements, primarily because of the confusion or the reluctance or the concern by not just state officials, but tribal officials about sharing authority. And really, it's a much better situation where we have cross-deputization. And we have some areas in the state where sheriffs are dead set against it. We have other areas in the state where tribal officials are dead set against cross-deputization. And it's really baffling to me why that is, because ultimately it serves everybody. And it's really essentially an insurance policy for that officer to make sure when they're responding to a crime that they're not on the wrong side of the line. They're not going to be subject to a liability if there's a use of force or something goes wrong or evidence is collected and it's all thrown out because they were on the wrong side of the line. Now, tribes can also just directly cross-deputize state, city, or county officers and not even involve the Bureau of Indian Affairs. Of course, those individuals could not exercise or have the authority under federal law to act as a federal officer. And I'm going to walk you through this process, but basically the base agreement is kept by the Oklahoma Secretary of State. It's filed and it's searchable on the internet. And then when every tribe or tribal government or state or county wants to add on to the cross-deputization agreement, ultimately it is uploaded to the Oklahoma Secretary of State's website. And when that happens, then everybody's aware of what this authority is. And again, obviously the purpose for this, if without cross-deputization, a tribal officer wouldn't have authority over a non-Indian except for these limited DV cases. BIA officers would not have jurisdiction over non-Indian versus non-Indian crimes or non-Indian victims crimes. And state officers would have no jurisdiction over a crime committed by an Indian within Indian country. Now, cross-deputization is not department-wide. It affects only an individual officer. There's been some confusion about that, but it only is the specific officer that's cross-deputized. So essentially, if it's a state officer, they can get a tribal hat and a federal hat and act under tribal and state authority. If it's a tribal officer, they could get state authority and federal authority. It doesn't change anything about the jurisdictional matrix that we described early on. It doesn't change anything about the department. It only affects the individual officer. So it will simply be determinative of each officer what authority that they have. Okay, one of the biggest problems is this myth or misunderstanding that somehow being cross-deputization, subject to a cross-deputization agreement or having one of these agreements in place creates liability. It doesn't create liability. It protects an officer from liability. It protects the evidence that's collected in connection with the crime. It protects people responding to crimes. And most importantly, it protects victims of crimes, because if you call the local sheriff and the sheriff is the closest one and it's going to take the tribal police an hour to get there, or BIA police an hour to get there, or vice versa, it doesn't make any sense to continue to have these artificial barriers between these different departments. So, you know, one thing that I always do when I do a training is like ask who would ride around of these officers, who would ride around in a vehicle without insurance? I mean, nobody would do that. But that's essentially what having these cross-deputization agreements in place provides. It's insurance for the officers. It's insurance for protection of the evidence that's collected, and it's additional protection for the general public to make sure that crime is going to be responded to, and that ultimately somebody is held responsible. And that's essentially what's described here. Civil rights liability, of course, most law enforcement officers are protected by what's called qualified immunity, but they have to be acting within the scope of their authority. So if a state officer is going on Indian land and collecting evidence, or, you know, has a use of force or something like that, were they acting outside the scope of their authority? Probably. They probably would not be subject to claim qualified immunity depending upon the circumstances. So that's one reason in and of itself that law enforcement officers should be utilizing cross-deputization agreements, working together. Okay, so how do we get this started? Is it something that's run by the federal government from the Department of Justice? The answer is no. Again, these officers, if you go through the SLEC route, they are becoming officers of the Department of Interior Bureau of Indian Affairs. And it's the Bureau of Indian Affairs, law enforcement, that's in charge of cross-deputization. The U.S. Attorney's Office doesn't really have anything to do with it. The FBI doesn't have anything to do with it. It's really essentially run by the Bureau of Indian Affairs. So if you want to get into this process, if you're representing a client that either state or tribal that wants to utilize cross-deputization, you need to contact the Bureau of Indian Affairs, District 2. We're in District 2 here in Oklahoma, special agent in charge to get the process rolling. They're the ones that set everything up. They're the ones that control it. They're the ones that ultimately determine who gets a SLEC and who doesn't. So there are really, like I said, two options. You can have a tribal in a city or state agreement that doesn't involve the federal government, doesn't involve an SLEC, doesn't involve the Bureau of Indian Affairs at all. Or the better route really is to have a tribal, city, or state agreement that does involve the federal government. And why is that? Well, then you're going to get all three coverages. You're going to be able to collect evidence with federal authority, tribal authority, and state authority. And oftentimes you really don't know if a case might ultimately end up to be a federal case. So we don't want somebody who doesn't have federal authority investigating a federal crime or collecting evidence. The option one, without the federal government involved, of course, the tribe can decide, hey, we're going to cross-deputize with a state or local government, provide, whatever guidelines or requirements that they want. They obviously should probably submit what they've done to the Bureau of Indian Affairs so that they at least can know what's going on and track the fact that there's a cross-deputization agreement, but it doesn't require the federal government, Department of Interior, Bureau of Indian Affairs to approve it. It's just really a record-keeping thing. Option two, which is a better course of action, is to utilize this base 2006 agreement for getting a federal SLEC. And in order to do that, the tribal government has to approve it. And then whatever municipality or county or state agency, whether or not it be OBN or which is the Oklahoma Bureau of Narcotics or some other state agency, all of those have to be submitted to the Bureau of Indian Affairs, those base agreements. So the base agreements, the addendums, the tribal resolution, the city council resolution, whatever it is, to put all the legalities in place for the agreement between these governments. And then on a top of that, again, that doesn't complete the process. That's just laying the groundwork for an individual officer to then go and say, okay, there's an agreement between this tribe and this state agency, and to have cross-deputization, I'm Officer Smith, I'm Officer Jones, I want to be qualified to have that authority. And what does that involve? Well, here's a list of the things that officer has to do. So one of the issues is a lot of people think, well, we've just signed this agreement, we're done. Well, no, that's really the beginning step. Again, each individual officer has to complete a written application. They have to have a background investigation. The FBI has to take their fingerprints. They have to pass a firearms course. They have to have police academy certification. They have to be a full-time police officer. They can't be a part-time deputy sheriff or part-time city officer. They have to be a full-time peace officer if they're with the state. They cannot have any prior convictions for domestic violence. They can't be subject to a court order. They have to agree to comply with the BIA Code of Conduct and Ethics, and provide a state driver's license. And then a lot of you have heard about this CJIC, this Criminal Justice in Indian Country course. It's a crash course, and that's where the U.S. Attorney's Office gets involved, because we give a crash course in all aspects of federal jurisdiction, Indian country, federal law, federal procedure, because we want these officers out there to understand what do they need to do in order to function as a federal officer, because they're going to be a federal officer. They have to take a test. It's a very difficult test, actually, and they have to pass it with a certain percentage, or else they're not going to be able to get that SLEC. This is the contact people presently in Oklahoma City: Kelly Maytubby with the Bureau of Indian Affairs and Brian Stark. And their district office is located in Oklahoma City, and they're the ones in charge of the SLEC protocol. In other words, once these agreements are in place, when an individual officer wants to utilize this procedure, they're the ones that take the application. If it's a local county officer to get cross-deputized, again, we rely upon this 2006 base cross-deputization agreement. They have to get the addendums approved, and the city council resolution or county commissioner or whoever it is. The tribal government has to approve, and it has to be each tribal jurisdiction where the officer's patrolling. So if the county has 2 different tribes located in it, you got to get it from each tribe. You submit these addendums and everything once they're authorized to the Bureau of Indian Affairs Office of Justice Services, and they're the ones that give it to the Oklahoma Secretary of State to upload if everything is in compliance and everything is properly executed. The approval process requires a completed application for each officer, and the Bureau of Indian Affairs reviews all of those in the background, the fingerprints, all of that stuff, And if they're approved, it goes off to Washington. Washington authorizes the issuance of an SLEC. That comes back from Washington, and then that officer is sworn in by the assistant special agent in charge or the special agent in charge, and they're a federal officer as part of the Department of Interior for a period of 5 years. If it's a tribal officer and they want to get this SLEC, very similar process. They go through the base cross-deputization agreement. They have a tribal addendum. They don't have to get the county involved, because if you're just having a tribal officer getting federal authority, not state authority, then the state or local government wouldn't be involved. And basically, you go through the same process, submit all this paperwork to the Bureau of Indian Affairs, and they're the ones that approve it. This is a photograph of some Chickasaw Light Horse Police that were sworn in as officers of the Oklahoma Bureau of Narcotics. That was some years ago. I was actually present for that particular swearing in. It was a pretty impressive thing to see that many tribal officers sworn in as state officers. This is the checklist, and it's basically I've signed a signing official will review it at the bottom here, but they have to make sure that all of these things are done. And this is where we're having problems, quite frankly, where we have people take this criminal justice in Indian country course and pass it and think, oh, where's my commission? Well, that's just one of multiple steps that have to be executed in order to get a federal SLEC. And that's the biggest problem that we have is a lot of the officers don't go through and submit all of this information. Now, once that SLEC is issued, again, the qualified immunity attaches. That officer can be treated as a federal officer if they're assaulted, and also provide some protection from certain types of claims brought under 1983 or Bivens type claims that might be brought against an officer in state or federal court. Again, so long as they're acting within the scope of their capacity, they would be defended by the U.S. Attorney's Office if they're acting as a federal officer, and they would have certain immunity. And this concept of insurance comes into play because for certain types of crime or criminal actions that are challenged pursuant to a civil rights law, such as the Bivens type actions or under 1983, the federal government can be substituted as a party defendant for certain types of crimes. And if there's a judgment that's ultimately entered as a result of what the officer did, then it would be coming out of the federal treasury, not out of that officer's pocket. So that's another reason why it's advantageous for these officers to get this cross-deputization in place. We have literally hundreds of these agreements in place. But nonetheless, we still have a lot of agencies and a lot of counties and a lot of tribes, honestly, that have not utilized this process. Now, it doesn't have to be one size fits all. A lot of these tribes will determine, or the counties will say, okay, we're just going to have a cross-deputization for this facility or for these types of crimes. So it can be tailor-made to the specific instance, a specific situation that we want coverage here. This is that same chart that I showed you earlier. And I'm going to go ahead and conclude at this point. And I think we've got a little bit of time. And we do want to take another break here. Let me see if I can stop the screen sharing and come back here again.
Okay.
We're pretty much concluded.
Well, thank you, Arvo. That was a wonderful presentation. Okay, everybody. Your next word is Cherokee. So if you'll add that to the word, the previous word, and add that with your name and your bar number, there'll be two more words before the end of the presentation that you'll submit at the end of the presentation to Oklahoma Indian Bar Association at yahoo.com. We'll go ahead and take a break. Let's come back at 3 o'clock. And the next speaker we'll have is Kurt Kickingbird. Okay, thank you. It is almost 3 o'clock. Make sure I've got my headset on. Okay, it's almost 3 o'clock, and we'll go ahead and get started with Kurt Kickingbird's presentation. Kurt Kickingbird is a member of the Kiowa tribe and the Kiowa Gourd clan. He's devoted his professional career to helping Indian people get interpretations of the law that will benefit their personal interests as well as the interests of tribal government. His expertise has enabled him to work effectively in legal, political, academic, and business arenas in order to ensure that the Indian viewpoint is taken seriously. In his work, Kirk has provided training and technical assistance to more than 150 tribal governments within the United States and Canada, and has worked with the United States government and world experts on international treaty issues affecting Indigenous peoples. Kirk joined the firm of Hobbs Strauss in 2000, and today is working on gaming issues for Oklahoma tribes and tribal government reform. In this capacity, he assists in revising constitutions, drafting ordinances, and lobbying state legislators and the governor's office over policy developments and interpretation. Kirk also works on tax issues in response to federal tribal tax commission inquiries, and he provides a valuable link between the Washington, D.C. establishment, academia, business, and the Indian community. Kirk has written extensively on matters related to Indian law and tribal governance, beginning with his first book in 1973, 100 Million Acres, nominated to the Pulitzer Committee. In 1987, his book, Indians and the U.S. Constitution, A Forgotten Legacy, was honored by the U.S. Bicentennial Commission. While executive director of the Washington-based Institute for the Development of Indian Law, he and his staff wrote a popular set of books for tribal leaders. And he also has a fabulous wife, Lynn Kickingbird, who supports him in every way. So, Kirk, I'll go ahead and turn it over to you.
Okay, I've suddenly discovered that my office has terrible fluorescent lights, and I have this green cast. All right. Today, we're going to talk about research on reservation status, primarily because it's cropped up again in conjunction with the decision in McGirt, and a lot of scampering around and trying to figure out where tribes stand with respect to the reservation status. Next. Next. I started out working on treaties back in 1968, when at the end of my second year in law school. John Belinda was director of the National Congress of American Indians. Vine Deloria had just left that post. And they came down to Oklahoma to discuss a treaty project. And the idea was to review the 400 treaties and agreements between the tribes in the US and figure out what that meant in terms of current rights. Next. So, looking at these agreements, assess whether the treaties could be used to assert tribal government rights and powers today. And with the goal of exploring how treaties could be used to protect tribal interests today. And so, this preliminary assessment was done in that summer of 1968. Next. Okay. Vine was to be the project director, and he left NCAI to go to law school. His experience in running NCAI was that he felt his comments, his suggestions, his policy ideas weren't taken seriously by Congress or the executive branch because he wasn't a lawyer. And he set out to promote the idea and encourage tribal members to go to law school. And his plan was to finish and return to law school. And then John would go to law school and return to NCAI. So to build a cadre and a core of people there who had the right credentials, being able to impact Congress and the executive branch on Indian policy. Next. So Vine asked me, and John asked me to start this project. Now at that time, there weren't any Indian law courses. And so I went to the attic to read in the real law school, that's old Monette Hall back of the Union, and now houses the Western History Collection, which, by the way, is a place where you can do some research if you need to. They have a lot of congressional materials, Fred Harris and others who are members of the delegation. So in those days, Indian law was largely self-taught. We had one course at OU, which was the Joe Rarick's Indian law land titles, but it wasn't broad enough. So I ended up that summer wandering around the top floor in the library and ran into Maurice Merrill. And he asked what I was looking for. And he knew immediately where Cohen's was and where Kapler's were, and he pointed me that direction and sent me over there to look. So I spent my time reading Cohen and Kapler and Indian Claims Commission material and sending reports to Vine and John. The problem was the project was plodding and tedious, and there weren't any eureka moments, and the primary result was to give me an introduction to federal Indian law. And so that project ended with the summer. So Vine was finishing Custer Died for Your Sins at the time in 1968, and his publication date was 1969, and he was also finishing law school. In the fall of 68, John Belinda was not reelected as NCAI executive director, and 68, 69 was my last year in law school, so new NCAI leadership didn't pursue the project. So I got sworn in September of 69, and by October of 69, by the end of the month, I had been hired by the Congressional Relations Office in BIA. And that was part of the commissioner's executive staff, and our primary jobs were to provide backup testimony and coordinate BIA staff testimony on the legislation and policy. Now, some legislation had huge files, 2 or 3 inch folders with historical background and previous legislative proposals. Sometimes they'd go back for a number of years, a dozen years maybe, and sometimes. In those days, legislation took a long, particularly on Indian policy, it took a long time to percolate. And so in reading those files, you get to find out some are pulled from historical material, others are just old memorandum inside the agency. And so I lasted at that job till 71 through the Nixon Indian policy presentation, and we took that legislation around the country. But I'd gotten tired of bureaucracy, and Vine and Frank Ducheneau and I founded the Institute for the Development of Indian Law. It's an Indian Law Research Center, and the goal was once again use treaties to research and treaties to support tribal government authority. And our first project was a book called 100 Million Acres. And so the idea was to do the historic and legal research and advocate for a minimum tribal land base of 100 million acres. In those days, we had about 48 million acres, I think, now up to 56. For a time, we thought we had 40 million in Alaska to make 96, but that's, after Venati, that raised some questions. Anyway, this is the book. Next slide. One of the things I learned at the IDIL was about research, and one of our board members was an anthropologist, an historian, and she was working on the Pacific Northwest fishing rights cases, which resulted in the Bolt decision in 1974. That affirmed fishing rights and the right to half the catch. But one of those things that we learned, there was a fight about who could benefit from it, and the fight came down to treaty tribes and those who weren't treaty tribes. So she began some research on who were the treaty tribes and went to the look at National Archive microfilm. It was worn film. She asked for a better copy. Next. So she was in line to ask for the next copy when she heard a researcher ahead of her ask about using less worn microfilm. They were all having the same kind of problem. And so Barbara asked how often the film was replaced. Well, it gets reshot periodically, but mostly they recopy it. Well, she went to and compared older film and with the copy she was using and found the issue. Then she went to the original document and found in shooting the microfilm, 3 pages were missed in that reshoot. And so these unrecognized tribes were actually treaty signers. And these, as a consequence, these unrecognized tribes had fishing rights. So that was a lesson about how things can get lost. Don't always rely on the original or the current version of the microfilm, but you have to dig down deep. Another thing that brought me concern or focus on treaties was John Belendo had become director of the NALDEF, the Native American Legal Defense Education Fund in Albuquerque. And Tom Lubin, who's the litigation director, and Dick Young, an attorney, approached us for assistance in DC with his treaty rights-based case. Alan Harjo wanted to file suit to enforce the 1866 treaty right to self-government. Next. So I agreed to assist, and I asked my law school roommate, Robert Vaughn, who's teaching at American U Law School, to be counsel of record. And so we went in and looked at statutory and historical material, and we rechecked some, we researched an original effort, and we confirmed what we needed to do, and we filed a lawsuit in '75. And so out of that, the problem they were faced is because of this attempt to destroy the 5 tribes' governments, the DIA Interior only recognized the principal chief as the sole embodiment of Creek government. Next. So back in '06, and the intention had been to terminate the Creek government. These were the intentions. Our judge said the nation survived the statutory dismemberment, and the Interior ignored Section 28 of the 1906 Act that continued the Creek government for all purposes until Congress said otherwise, and they'd never said otherwise, or at least they'd never continued on with this termination effort. The judges described the DOI's actions as unlawful and as bureaucratic imperialism without statutory authority. So about that time, I was appointed as general counsel to the Indian Policy Review Commission, and this was to look at the turmoil created by the siege at Wounded Knee in 1973. And I had to withdraw as counsel, but my colleagues continued on. And so the judge ruled the Creek Constitution must be revised so the Creek Nation can exercise its constitutional government in accordance with the treaty promises. And that was the Harjo versus Kleppe case. Next. Next thing I undertook was this Indian Policy Review Commission. And it was unusual as a congressional commission because it had 3 Senate, 3 House members, and 5 Indian civilians. Year 1, we looked at 11 different subject matters through task forces. Year 2, we consolidated into a final report, and the published material went into 8,000 pages, or over 8,000 pages. There was a 2-volume final report, and it set the foundations for policy since 1977 in a couple of ways. Next. This is the reports there. It's a massive one on its side there, number 10. That's treaty rights. Next. Well, its impact was because the staff who left the commission, and there was 120 at one time, ended up working for Congress and executive branch Indian agency programs. Also, the task force personnel did some extensive archival research. And all this strengthened resources in Indian law. Next. So, in our current controversies, research needs to continue. Begin by reading treaties carefully. Make sure what you have there. Does it actually say there's a cession of the land? And if so, what does that impact? You need to get into the statutes that surround that, because there's usually not only a ratification of the agreement negotiated by the Dawes Commission or the Jerome Commission, or someone else working for Interior at some point in this 1901 period. And then we probably litigated this stuff at some point. So read those decisions carefully. Take your time, become really familiar with the phrasing of what it says. And out of this, we think the foundations and questions have been set for decades and centuries. But you can have an impact like that Hydro case or like this McGirt case. So in becoming familiar with the treaties, and there's usually a sequence, sometimes they begin as early as 1835 out here in the plains, another series in the 1850s, another series in the 1860s. And after that, you get a variety of statutes that may have impacted, and then of course, any negotiations for allotment that come into play. But look at also not only the language, but the proceedings of the treaties. And sometimes there are official federal reports. There may be federal reports from other participants. There may be Army officers who attended. There'll be journals of guys who were attending and negotiating. There may be correspondence with traders or prominent citizens who attended, and there may be even newspaper reports. All these can come into play to help shape what your argument might be for continued current rights. Now, some of these things you'll have to go to find in the National Archives or university collections or museum collections. Next. Now, our standard resources to begin with are the same ones I began with in 68, was the Handbook of Federal Indian Law. I urge you to take a look at the 1942 edition on the same topics that occurred covered in the present day, because sometimes it can provide insight into the way the law developed, or little comments there that give you some enlightenment or information that'll help you figure out a potential argument, because because Cohen sometimes commented on the philosophy at the time. So look at go back one. In addition, you've got to review the current edition, get your all those cases up to date on there. Then you can refine your research with your electronic research. Also look at the legal conscience when you get a chance. That's a compilation of Cohen's writing. There's in 3 sections. One's philosophy, but the ones that more important to us is the section on the Indian's quest for justice. And these law review articles of his will help you also get an idea of how to write about the issues, some of the philosophy about the issues, and I think will be useful in your practice. So, another standard resource is Kapler's Laws and Treaties. Now, the original went to 1938. Volume 2 of that series is treaties. The others deal with statutes, public laws, the executive orders, and I think even some later stuff has Federal Register materials relating to tribes and a variety of issues, including land returns by the BIA. So, in 1968, the Indian Civil Rights Act had a section that required Kapler to be brought up to date, and that's where volume 6 and 7 came through, and that brought things up to date through 1970, and those volumes were published in 1975. Next, here's those blue volumes, and you can see the shinier gold on the 2 new volumes 6 and 7. Also over there in the corner is Opinions of the Solicitors, which also is sometimes a useful resource. It has it's a compilation of the opinions of the solicitor dealing with the Indian affairs. Next. All right. Another useful tool is the Doomsday Report. Now, William the Conqueror invaded England in 1066, and he wanted to know what he held. So this survey included a census of peoples and animals and crops and forests and other economic resources. And it was called the Domesday Survey. But it pronounced, that is, it was said to contain the kind of information St. Peter would have on you at the gates of heaven on Judgment Day. And so that's why it gets this name as Doomsday Report. But there's another reason you'll see in a minute. Next. There was a Doomsday Report on Indians. In 1952, Congress set out to conduct a similar survey of the BIA and Indian tribes. And this report is 1,500 pages in length. It's House Report number 2503 in the 82nd Congress, second session. It was completed December 1952, but published in 1953. Next. Here's the cover sheet. Its official name, of course, is the House Report 2503. Next. So one of the things that was happening at the same time, this is a forerunner and led into the termination policy, because one of the things that happened was the most economically successful tribes were targeted for termination. So House Concurrent Resolution 108 was passed August 1st, 53, and that made termination of tribal governments the official policy of the United States. Next. So finding resources. Most of you have access, know how to use electronic legal research providers. College and university libraries also have legal and historical research that you can find. There's a Library of Congress, the internet, of course. Google Books has a bunch of these congressional reports on these items. The Oklahoma History Center, in their research center, has in the 1930s, a lot of the original materials for the Southern Plains Agency offices were transferred to the Oklahoma History Center, and they're there now. Those, in fact, many of those are found in original documents. You have to go in and use the white cotton gloves to look through them. But they also have most of the microfiche and microfilm that you're going to need to do background materials and get into, if you have to get into really in depth in your research of looking at correspondence between BIA offices from the field offices somewhere out in Oklahoma or Kansas or the Dakotas back to DC, and it goes back and forth. So those can sometimes be really useful. Next. The internet contains the congressional serial set, and it's referred, sometimes just called the serial set, but it contains House and Senate documents and House and Senate reports bound by each session of Congress. And it began publication back with the 15th Congress in 1817. Next. So documents before 1870 can be found in the American State Papers, but in general, it includes committee reports related to bills and other matters, presidential communications to Congress, treaty materials, executive department publications, and non-governmental publications, sometimes that have been given or sent to Congress for a variety of reasons. So it can be found now very conveniently, most of the stuff that you're interested in, at OU Law School in the Digital Commons. And it's under the American Indian Alaska Native documents in the Congressional Serial Set, and it stretches from 1817 to 1899. You can find the other materials from the Congressional Serial Set available at Federal Deposit libraries, and much of it is you can get through at most college libraries. Next. So, Library of Congress is another location to get resources, and this one's statutes at large. Most of those are available at law schools, but sometimes it's more convenient nowadays, particularly in the COVID era, to work from home. You'll find some interesting things there. In Appropriation Acts between 1884 and 1925, Congress refers to reservations of Western Oklahoma tribes. Next. And the phrase will often appear in those appropriation acts in this manner: for subsistence and civilization of the Arapahoes, Cheyennes, Apaches, Kiowas, Comanches, and Wichitas, who have been collected upon the reservations, set apart for their use and occupations. And these references come before and after allotment. They begin, I've only looked so far as 1885. They go up to 1909, 1910 for many tribes, and even continue on into 1925. In 1925, the format seems to change from funding subject matter like education or some other general topic rather than the specific state and tribe that occurred before that time. And quite often, some of the detailed references to reservations really deal with small tribes who needed, who had no other sources of income. They hadn't sold off large reservation lands under the allotment to the homesteaders. So this is, be careful. You need to get into capillary. You may need to get into the statutes at large to take a further look at this. And fortunately, most of these things are searchable. So you don't have to pour through 30 pages of single-spaced statutes on appropriations. You can narrow it down if you get your range of tribes, reservations. If there's more than one tribe, like Cheyenne Arapaho or the KCA, check all those names just to make sure you haven't missed anything. Next. There's another interesting thing in this Doomsday Report, and this is one of the values it has. Although it's set up, you know, the better off tribes economically as candidates for termination. There's this little notation on page 109. There's a chart of law and order, and it lists all the tribes and all the states. But in 109, there's a footnote, and this is from page 104 where Oklahoma is listed. Oklahoma is just blank. All the columns are blank. Footnote 11, and this is what footnote 11 says. The state handles all law and order problems and finances the same on the county basis. State jurisdiction on the Osage Reservation and all reservations other than the Southern Plains Agency is subject to court attack due to absence of congressional authority. Now, the Southern Plains Agency handled the tribes who weren't 5 tribes or Northeast 8. So that's virtually all the other tribes in the state who are in the category of being under federal jurisdiction. And we'll, as we see, and as Stacy reported, we've got litigation on seeking clarity on the east side of the state, and we're getting cases that are going to be addressing the same issue on the west side of the state. Next. Okay, there's another chart in the Doomsday Report. It's on page 1090-91 and shows all the tribes under the Anadarko Agency as having a reservation. That same group of tribes, the non-5 tribes, non-Northeast 8. And the report gives the historical and legal history of Oklahoma tribes and refers to the land base as a reservation. In that chart, each of the tribes under Anadarko has an R by it, and the little legend says R equals reservation. So this is also an interesting piece of information to apply in any arguments about whether the tribes in Oklahoma have ceded their lands or whether allotment had a different impact than everyone imagines. And it's the same kind of presumptions on the east side we saw in Harjo, that we saw in Nowabi before State versus Flint corrected that case. And so there will be some interesting litigation here in the next few years. Next. Here's a link to the Doomsday Report. And I've been kind of presuming that Stephanie and Arvo will make this available to you, this PowerPoint. Next. There's also, here's a link to Kapler's. And that's once again from the, it's volume 2. Next. Or you can go to the Library of Congress and download Kapler's. Got enough space on your computer. I don't know how often you'll need it, but it's certainly useful to have it available when you're not traveling out as much as you are during COVID and getting out to these university libraries. Next. that's really all of the presentation here. And I'm glad to stop and see if you have any questions, see if I can answer them. But these are the base things to start with your look at reservations in Oklahoma.
We don't have any questions that have come up on the chat right now. If anybody does have any questions, go ahead and put them in the chat. And what we'll do right now is, let me give you the next word for the CLE. The next word is ponca. Ponca. So go ahead and add that to your other two words. We will have you put your name, your bar number, and the 4 words, of which there's 3 right now, and send those to Oklahoma Indian Bar Association at yahoo.com. What we'll do right now is we'll take a 5-minute break and give everybody a chance to stand up and get something to drink. We'll come back at 3:35 with Robert Gifford. Thank you. Okay, we'll be coming back on in a couple of minutes. Not a couple of minutes, a couple seconds, because it is now 3:35. Okay, our next presenter is Robert Don Gifford, and he is the founder of Gifford Law in Oklahoma City. Mr. Gifford is a trial lawyer with over 20 years experience in federal, state, tribal, and military courts, with a practice in civil rights, criminal law, Native American law, military law, family law, and government contracting. Mr. Gifford also represents tribes, companies, and small business owners in preparing for criminal compliance and corporate risk assessments, as well as being a nationally recognized cannabis consultant to entrepreneurs after the legalization of marijuana in Oklahoma. Mr. Gifford's unique background with a career as a former federal prosecutor with the U.S. Department of Justice, a retired Army Colonel, JAG, active duty and reservist, a tribal court judge, a former assistant district attorney, a municipal judge for the city of Oklahoma City, an adjunct law professor. Prior to going into private practice as an assistant AUSA in Oklahoma City, where Mr. Gifford has served as the tribal liaison, human trafficking coordinator, anti-terrorism coordinator, and Project Safe Neighborhoods coordinator for the U.S. Department of Justice. He is also a renowned legal educator. Mr. Gifford has served as an adjunct law professor with the law schools at the University of Oklahoma, Oklahoma City University, and the University of Arkansas, teaching trial advocacy, military law, and homeland security law. And he has been a guest speaker at the Sovereignty Symposium, the Creek Nation District Court CLE, and for dozens of continuing education classes for the Oklahoma Bar Association. I had to really cut that short because Mr. Gifford has a very impressive resume. So if anybody's interested, you can always look at his website. And he also goes by Bobby Don. So if you see him around out in Indian country, say, hey, Bobby Don, I saw you on the CLE. Thanks a lot.
Thank you, Stephanie. And thank you, everybody. The purpose of my presentation today is I want to focus on sort of what's been happening out on the ground today. It's been interesting to see I guess the education of Native American law to non-practitioners, lawyers who work in the state courts every single day, who are coming in and having to argue federal Indian law. And it's been interesting to watch the evolution. A lot of great lawyering that's going out there. This is probably, I think, I had this conversation with Arvo and with Steve Hager, that this is probably one of the greatest times to practice Indian law. And what's happened out there is, since McGirt came out, there was an incredible misunderstanding on both behalf of the state and even the defense attorneys who were representing various clients, whether it was post-conviction or pre-trial. And at first, the first argument, as everybody has kind of come around to, was it only applied to the Creek Nation. And I kept telling, and several of my colleagues kept telling everybody, this is going to move over to the Cherokee Nation, the Seminoles, the Choctaws, and it began to evolve from there. It just so educating folks, it just didn't apply to the Creek Nation. And then there were questions where people were asking, well, do they have to be a member of the Creek tribe? That was a whole nother education. Then it became, it only applies to major crimes. And that's probably been the biggest part of the education. Right now, I believe in Tulsa County, there are still some issues with the writing of traffic tickets. And I was just answering questions on, I guess, a Facebook listserv dealing with, the jurisdiction over natives on traffic tickets by a municipality. The education keeps going, and nobody really seems to be on the same page of music. I'm aware of one DA's office that made an argument that a tribal member of the Choctaw Nation was not Indian enough to have McGirt apply, even though they had a CDIB card. They were a member of the Choctaw Nation, and the charge was basically going to be within state court. The state's position was that this individual was not Indian enough for prosecution and that there needed to be a line. Where this argument came from, I don't know, but I know that it stirred up quite a bit of controversy in making that. There's also been arguments, and are still making arguments that only applies to the major crimes, and having to argue what jurisdiction actually means. In fact, I think I was able to explain it when I explained. They understood that the state had no jurisdiction within a casino, and I made the analogy to say, well, just imagine that the large part of Tulsa County now is one giant casino. They seem to understand that concept, but even though it's by far not the legal analysis that was needed, that was one of them. So right now, across the state of Oklahoma, we have assistant AGs or state prosecutors. Some of them are arguing that they're not Indian enough, even though they do have a CDIB card and are a tribal member. Number two, because they don't have their Indian card at the time, and they're not an enrolled member at the time, but they're eligible to, McGirt doesn't apply to them. That argument is going on right now in Tulsa County. There are arguments that are arguing that it only applies to major crimes, which is completely incorrect. Some are even talking about, traffic citations are neither in Oklahoma are not misdemeanors or felonies. Therefore, there's something else. Therefore, the state or the city still has jurisdiction over those who are Native American within the Creek Nation. Now, right now, and you may have talked about this earlier today, we have decisions from the Supreme Court on the Creek Nation. We have state court decisions in regards to the Chickasaw Nation, the Choctaw Nation, the Cherokee Nation, and the Seminoles have been automatically, dismissing cases right away. In fact, I believe Seminole County, the district attorney's office, immediately after McGirt started dismissing cases in their jurisdiction immediately. They didn't wait for any guidance. They started dismissing, which I had to hand it to them. They were doing the right thing. And I believe they started coordinating with the Seminole Nation as well, as far as which ones can be prosecuted, which ones cannot, and also coordinating with the U.S. Attorney's Office. One of the big criticisms that I've seen is, these individuals, and I know you've heard this earlier today, are not going to be prosecuted at all. False. I believe Mr. McGirt was re-prosecuted and convicted, was it last week or the week before? The U.S. Attorney's Office has been able to handle all the influx of cases. I know that on an average month, the U.S. Attorney's Office in the Northern District, there in Tulsa, would have roughly around 6 to 10 indictments a month. In 1 month, they jumped up to 60 indictments. The Eastern District of Oklahoma in Muskogee, theirs have increased right as well, but they have adjusted. They brought in additional prosecutors. They brought in additional agents. They have been cross-designating and working with the tribal courts, tribal law enforcement. They're working with special assistant U.S. attorneys, tribal attorneys who are being appointed to work in these matters. Defense attorneys, they are now having to reach out to attorneys all across not only the state, those who don't normally practice in federal court are being introduced into federal court by being brought in to handle these McGirt cases. The thing that I think is interesting is that they're even bringing in defense attorneys from Denver, Colorado, from Wyoming, attorneys who have some experience in working Indian country issues are now coming into Oklahoma to help work these cases. It is a great time to be a lawyer. It is a great time to be a part of this, but it has been an education, both on the prosecution side and on the defense bar side. And at some point, I'm hoping that some of these issues will get kind of hammered out. And I'm turning my head here, so forgive me. I just want to make sure I see a message coming in. Just want to make sure I get all any questions. Let's see. One of the questions is, let's see. As far as the I have testified just in the last month or so in regards to a McGirt issue. Some of the tribal court judges were unfamiliar with Native American law, Indian law, and so the defense bar was started to bring in attorneys who practice in the field to educate the judge on what who qualifies as a Native American. What does Indian country mean? How is it defined? How does McGirt apply to these current cases? We also have some cases where judges who are outside of those normal areas are having to hear these cases. For example, and what I'm referring to is post-conviction. Typically, when somebody has lost their appeal, they're past their appeal, they're serving their time, and they're serving within the Oklahoma Department of Corrections, they may be sitting in a county far from where the crime occurred, outside of the Creek Nation, outside of the Cherokee Nation or the Choctaw Chickasaw, but they want to raise their post-conviction appeal. And so they're raising it within the county that they're serving in. Right now, for example, Comanche County is one example. They do have a prison that is there. What has been happening, though, is that even though historically that county always heard those post-conviction appeals, or what they're doing is they're hearing these, when I say appeal, habeas actions, they are actually kicking them back to the original county where it was heard. That way, everybody can hear more of it's where the location is. The DAs there are starting to handle these cases more and more. They're getting more educated. I know there for a while, the district attorneys and the judges were sitting in on video conferences, Zoom calls like this every Friday just to get educated. I was in a judge's chambers not too long ago in Osage County. And when I started talking about McGirt, he reached up, pulled out a binder that was about 4 inches thick. And of course, he'd been briefing and getting all kinds of information and trying to get up to speed and educated on how does McGirt apply to Osage County, if it does. In this case, there's still a lot of education that needs to be done. We're not on the same page of music. I think while the state attorney general has been leading this and getting education out to the assistant DAs at the county level, there are so many counties that still don't know or understand what's going on. In the defense bar is asking a lot of questions, and they're looking for answers in the newer counties. My understanding is that the Miami tribe, there was a finding about a month and a half ago, that they found that the Miami tribe of Oklahoma, their reservation was still intact. That was the first tribe beyond the five major tribes, what they call the five civilized tribes for historical terms, but not really the most appropriate term anymore. The Miami tribe of Oklahoma, their reservation is still intact. I believe that's now getting ready to go up it's in the process of going up on appeal by the state, but that is the first one of the five tribes to make that finding. Some of the other defense attorneys out there are doing the research and history in the other areas, such as the Cheyenne Arapaho, the Kiowa, the Comanche. They're trying to see if those tribes, those who didn't really necessarily have treaties, but their reservation rights were abolished by other means, if there is a way to take McGirt, apply it through a non-treaty action in which they lost their reservation. That's going to take a lot of history. There's several tribes, though, they don't have the history. They don't have the documented history. The Creek Nation was lucky they had it. The Cheyenne Arapaho have a great documented history, even though they are not, their reservation was not abolished by a treaty. That's where it began. And with McGirt and Murphy before that, I find it fascinating that it really took a fresh set of eyes, a lawyer who was not grounded in Indian law, to look at it and ask, why not? And start pushing that and start doing the research and the history. And that's how we got to where we were with the Murphy case and then McGirt. I'm looking, Mr. John Paris, he mentioned some counties are raising latches in post-conviction cases. And that, thank you very much, Mr. Paris, you're correct. The DAs are arguing that because the issue wasn't raised before, latches applies, that they have lost it. Now, of course, going back to law school, you can raise jurisdiction at any time. And that argument has not been successful as far as the latches. at least to my knowledge. It might be, and I'm not aware of any district judges doing it, but I know some assistant DAs are arguing that as well, that if it wasn't raised early enough in the pre-trial or during trial, then they can't raise it now. So that's been another interesting legal argument to go back, and it's almost kind of first year law school again, where they're saying, no, this is jurisdiction. You either have it or you don't, and it's not a little bit of both. There's also some legislation that's been, or excuse me, there's been some litigation that's been out there in regards to how McGirt applies to court fines that were paid. I believe that there's a class action suit filed in the Northern District, and I believe that there might be one, I believe, filed in Okmulgee County as well. So the McGirt tsunami is ongoing and applying in a lot of different ways. And I think there's going to be a lot of questions for people in other areas of the law. I know that one person has even approached me to ask me, well, if they never lost the reservation, then the land that was passed on was never properly passed on. So how do I know if I had a good title to my home? I think those are questions that still have to be resolved as well. In the state courts, and and also with state prisons, there's a lot of letters going out, people asking, I believe that I'm Native American, how do I do it? And we're really starting over from ground zero with a lot of cases. Some people finding out that they believe that they're eligible and they're not. Some who should be eligible, but trying to prove it is a lot harder, simply because they were either adopted at some point, there's no documentation, they don't have much information from their family history. So you're really having to do a lot of work to even get the case off the ground, to see if even if they have a case, for those cases that are applicable, the ones in the Creek Nation, the Cherokee Nation, Choctaw Nation, Cherokee Nation, Seminoles, and now the Miami Tribe of Oklahoma. They are all starting to raise those issues as well. I also believe, and I believe that we're going to see in the next year or two, that there might be another successful argument with some of the other tribal reservations as well. So I have my odds bet laid on one tribe specifically, and I think it has a very good shot at getting its reservation back. There are others, I think it's going to be really hard, simply because there's a dearth of information out there that you can't really prove it, because there's really not a whole lot of documentation as far as their historical information and how they lost it. And if you don't have that treaty and it was done by executive order, that's a lot harder battle to overcome. McGirt has to do with jurisdiction, and it's on the listservs for the Oklahoma Criminal Defense Lawyers Association, or on some of these Facebook listservs for Oklahoma criminal lawyers. You see these questions, and you see other people coming back, it's jurisdiction. And they say, but what about this? It's jurisdiction. And it's been kind of interesting to see how resistant some judges, some prosecutors, some from the AG's office have had at coming around at arguing this, to say we are back to something very basic. If we're talking about whether this occurred in Texas or Oklahoma, or Kansas and Oklahoma, or Arkansas and Oklahoma, you wouldn't be having this argument. But just because it's happening within the historical tribal reservation of the Creek Nation, it's no different. And there is an analysis, depends if your client is native or non-native, but it has to be asked. That analysis has to be done. And what's funny is they're doing everything they can to fight against it. So it's been an education. And as a lawyer, it's a beautiful time to be arguing this, and finding people, and you're walking through the process. Even those who are they've lived as natives, but they don't have their card, walking through that process, getting their CDIB card, their tribal card, raising the issues in the tribal court, whether it's something as simple as a traffic ticket or something even more serious as on the felony level, it does apply. And of course, some of the questions that I've been fielding is, okay, I have a client, he meets this, I think that this will help him, but do we really want to raise the issue, because do we want this handled federally or not? And it also gets into the ethical quandary is, okay, under the rules of professional responsibility, you have a defense, but you may be subjecting him to a greater punishment in a different courtroom. So that analysis is going on. A lot of people are trying to question themselves as to This is something I know as a fact, and I don't want to bring it to anyone's attention because I have it resolved here in state courts, and it's in my client's best interest. But then again, what happens when the judge asks, is he Native American? And that's a question that lawyers, they got to be candid. They have to answer the question. So in the next few months, few years, it's going to be interesting to see how things shake out. I know they're talking about what legislation Congress might do. My hope is that Congress will see what's happening, that the tribal courts, tribal law enforcement, the U.S. Attorney's Office, the Department of Justice, they're working well together. And a lot of the state partners are coming on board now. It would be a shame to lose something where we've made so much progress. Are there some still questions out there? Yes. How is the state of Oklahoma going to handle back taxes? How are they going to handle moving violations? If you get points on your record, is it going to be properly counted? Those are all questions that, the state and the tribe still have to figure out, but it's not impossible. And it hasn't been raining cats and dogs like everyone thought it was going to happen after McGirt, but it has been a change. It's been an education, and it's been wonderful to see so many new lawyers and old lawyers, and old, speaking for myself, for folks who never knew or appreciated Indian law, who today are starting to get a grasp of it for the very first time in their career. And, I think I've heard over the years, there needs to be an Indian law question on the bar exam. I think after McGirt, I think this is a very good reason to add it for the future because it's going to be applicable across the board. And I'm looking over here to some more questions. Question came in, can a tribal client decide which jurisdiction he or she wants to be prosecuted in? Is that a decision he or she can make? Kind of going back to what I mentioned, okay, you have a tribal client being prosecuted in state court, and we'll say the Creek Nation. Of course, no one's asked the question. It's not listed whether or not it's a tribal member, but you as a lawyer know that your client is a tribal member, and your client may want to stay in the state court. The question is, is that something that the client can decide? With the analysis that I've done is that you have to look out for the best interest of your client. If it's best to keep them in state court where they can get a deferred sentence and it can be expunged later, that might be what's best for them. But the issue becomes, if the judge asks that question, do you have jurisdiction over somebody? And I think you have to be candid with the court. The second part of that analysis, and this is a little bit harder, whenever you do a guilty plea colloquy, for example, I'm in federal court, and one of the things I always have to make sure my client admits to that the crime occurred within the Western District of Oklahoma. Well, that's part of the plea colloquy at the state level as well. Did this plea occur within Tulsa County? Arguably, yes. But do you have to take it to the next level to say, that Tulsa County has jurisdiction? So I'd probably defer to some of my colleagues on how they might analyze that. But I think, my gut instinct is initially, if you have a tribal client and it's in their best interest to plead guilty in a state proceeding or a municipal proceeding rather than a federal court or a tribal court, then I think that's probably the option you might want to consider. But again, you always have to remember, that your duty of candor to the court. And I think, that's probably one that maybe the Bar Association might want to give us some guidance on as to, do we disclose that or not as defense attorneys? And I also know that some state prosecutors are asking for the same thing. If we don't raise the issue, then they'll offer a better deal. And I don't know whether that's entirely proper or not, but again, it's in the best interest of the client. Mr. Paris, John Paris, and I was unaware of this. Rogers County now has a form affirming that the defendant is not a tribal member. And I guess it's just more or less to help make the record, to try to help address things on appeal. But again, if someone believes they're not a tribal member, but later they find out that they're actually eligible for enrollment, or a tribe changes its enrollment, that's another question, and they become eligible, has jurisdiction been waived? I would always argue no. Jurisdiction can be raised at any time. But again, if Rogers County now has this form for someone to affirm that, I think that's probably wise to document that for the record. But again, when you have that rare circumstance where somebody becomes eligible. Now, here's the law school question. tribal membership for, let's say, tribe X requires a blood quantum of 1/4. And so when the person is charged with the crime and convicted of the crime, they're not a tribal member because they are 1/8. Well, a year goes by, 2 years goes by, and the tribe changes its blood quantum to 1/8. And your client is now eligible for tribal membership. Now, I know some of you are thinking, is that something that could really happen? Absolutely. Tribes determine their own eligibility. It is all up to them. And if the Cheyenne Arapaho want to change the blood quantum as to who can be a member, they can do that. That's a part of their self-determination. So if you have a client who was not eligible when he was convicted, but is now eligible after the fact, how do you handle that? I think my analysis is that if he is sitting in the Department of Corrections, if he's sitting in a state jail, that state doesn't have any jurisdiction over him at that point, and he does have a post-conviction argument to make. Now, I've not done the full analysis on that, but that would be my law school exam question that I would probably suggest to Dean Leeds for her to put on her future exams. And I know that she's doing a lot of education across the nation. But with that, any questions from anybody? And Mr. Parris, thank you very much, and Ms. Rowan, thank you for your questions as well. Any questions, or any of the other panelists? Do they want to jump in and throw their 2 cents in?
All right, so you posed a question. Now I'm going to pose one back to you. And that is, we've spent a lot of time talking about the practitioner in Oklahoma State Court, but there's a lot of people on this call that are practitioners that work for tribes. And as tribes are thinking through what's the tribe's next step in this, is there anything in terms of tribal legislation or tribal process that you want to throw out there that if you had control of the pen that you would like to see tribes do, or things that they might consider from a legal or a policy standpoint?
Yes, yeah, and if with the threat of legislation coming from Congress that's out there, number one, I don't think Congress needs to act, and this is why. The tribes can do this. The state of Oklahoma, if you're licensed in the state of Oklahoma and someone gets it and you get a DUI in Kansas, that's reported to the state of Oklahoma, it goes to your driver's license, it affects your insurance. Tribes need to be a part of that same program where if they write a citation, they do a DUI, that they are part of that same process in which they are required to report these infractions to these state agencies. So if you are a tribal member from the state of Kansas, you get a DUI in Lawton, Oklahoma, or you get a DUI in Tulsa County that's within the Creek Nation, and you plead guilty to that DUI, it will go a long way for the tribal courts and the tribal governments knowing that their stuff is going to be recognized elsewhere, and vice versa. They need to be a part of that same type of system. Secondly, the tribes need to be very, very careful and consistent in their punishments. One of the issues that's going to be raised in other states where these other states don't have any tribes or tribal jurisdictions, very foreign to them, they're going to question the due process rights of defendants when somebody pleads guilty in tribal courts. I've had the pleasure and the honor of being able to practice in a lot of different courts, different tribal courts, federal courts, state courts, and it's done so differently everywhere. However, I do see where in some of the tribal courts, when somebody pleads guilty, they're not doing the same things that they would do necessarily, say, in federal court. And I will tell you, that's what the U.S. Attorney's Office and the federal public defender, they're going to be looking at. Did they make a record? Is that record there? Did they go through all of those questions? Did they affirmatively waive their right to appeal? Did they waive their right to a jury trial? Did they waive the right to cross-examine their witnesses? Because when you don't make that record of those affirmative waivers as a judge, later, if somebody wants to challenge that tribal court conviction, if the U.S. Attorney's Office wants to use that tribal court conviction to enhance a sentence or whatever, they're going to run into those questions whether or not that person was advised of all of his rights. And we need to create these checklists for our tribal judges as well. The third thing, and this is, is our tribal courts, our tribal law enforcement. We need to be very consistent if we are brought a search warrant, an arrest warrant, or anything else like that, that we're following the same timelines that the federal government uses. If you have somebody who goes into custody, someone gets arrested on a charge, you need to make sure that they get an initial appearance and arraignment, within 48 hours. You need to follow the Supreme Court law on that. Otherwise, you're going to run into issues. Secondly, you want your tribal judges and your tribal law enforcement, if they're doing search warrants and arrest warrants, they need to look at some of the same forms that are used in federal courts. They go to the district court's website. You can download the same forms and check and do those, because the U.S. Attorney's Office, I would anticipate at some point, may be prosecuting a crime that our tribal court judges issued the search warrant on. So we have to be very consistent on making sure that if they challenge our search warrants in federal courts, that they're passing muster and they're holding up. And that's and I've noticed that as well, as that sometimes, in fact, since McGirt, I've started going back and looking at my arrest warrants and being a little bit more critical, because I realized, okay, this is not what I would have saw when I was an assistant U.S. attorney or when I'm defending a case. Even I as a tribal judge starts to, well, they're going to come in, they're going to plead guilty, it's going to be done. But if I get the phone call, this case is going federal, and they want to get all your court documents, you want to make sure that they look like what they're used to seeing in the tribal courts as well. I've also seen and I would encourage all the tribes to do a hard scrub on their statutes. Many of the tribes with their tribal codes may not be all encompassing. We need to probably start looking at our tribal codes, making sure that we have all these proper statutes. I know, like down to Comanche Nation, they are writing civil citations, even to non-tribal members, treating it as a civil matter. But, a lot of the tribes don't have that. Whether it's a traffic citation, a no seat belt, a process that meets more of the scrutiny of, what you might see in a state court or federal court. Not to take away from the sovereignty of any tribe, but we want to ensure that our decrees, our convictions, that our orders have the same weight and carry this and get the same full faith and credit that a state court judge would. And quite frankly, I've seen bad state court paperwork. I've seen good state court paperwork. But I think as a tribe, in tribal courts, we're going to get criticized first, and we're going to get criticized harder than, say, some rural county in Oklahoma or elsewhere that maybe their paperwork isn't up to par either. The tribes are going to get a little bit harder criticism, and it's going to be used as an argument why there needs to be federal legislation. And we don't need that. The tribes can do this. The state can work with the tribe, and the federal government's been successful at doing it. And sorry if I rambled on there for a second.
Oh, Arvo's back on. Did you want to jump in here? We got you muted.
All right.
Okay.
Just a couple thoughts about what you said, Dawn. I think it is very important for tribes to go back and take a look at their codes and make sure that there are not any gaps. I think most, some of the codes out there, of course, you can't cover everything, but some of the codes could say if there's not something addressed specifically by the tribal code, then we're going to, assimilate or incorporate state law or federal law or something, so that all bases are covered. Because oftentimes we'll be looking at, if there's an offense that maybe is not included. The other thing I think that's going to be important to look at is statutes of limitation. Some of the tribes have very short statutes of limitation, 2 years or 3 years. And it's going to be important to take a good look at those statutes of limitation to see if those need to be expanded or changed or clarified, to make sure that, on down the line, if things, get backed up in terms of investigations, we don't end up losing cases that might be prosecuted tribally. And if they're outside of the boundary of the statute, then that's not a good thing. And I think what Dawn said is absolutely right. Tribal courts are going to be scrutinized. at the federal level. And I've been in federal court, and I've had to defend state court warrants that have been nowhere near the standard of what a federal judge would approve. And that's not an easy thing to do either. A state court warrant sometimes will come in and you take a look at it and you're like, wow, and it's already been executed, and you gotta, go back and make sure that what was done is correct. And I think what's important is that the judges, when they make a decision, and even if it's in a court minute, tribal judges, what I'm talking about, go through, document everything, document as much as you can. That's where, and it doesn't have to necessarily be a typewritten order, and, of course that would be better. But, I rely upon tribal decisions quite frequently. Tribal court oftentimes will, if there's a criminal action, they can act more quickly because we don't have a bond schedule in federal court. In order to arrest somebody, it takes a lot more paperwork, which of course we do quite frequently, but oftentimes somebody's arrested over the weekend. If it's a tribal charge, they'll be in tribal court. And then utilization of tribal decisions tying into OSCN. There have been several tribes. I think the Cheyenne Arapahoes did for a time. I don't know if they still are, but they made some kind of arrangements where the tribal court decisions, the tribal court, at least the criminal cases, and I think some of the civil cases, were included on OSCN. And that's very important. Why? Well, let's say we have a defendant that gets arrested, and then we're trying to figure out, do they have any tribal criminal charges? Well, you may or may not know that if the probation office, who usually gives us a report when somebody's arrested as to what their prior criminal history is, they don't have access to tribal codes. They don't have access to tribal decisions. They don't have access to tribal convictions. And so, somebody might have a horrendous tribal history, and we will never know that unless we call down to the tribal court and somebody, starts researching it. So tying into NCIC, which is the National Crime Information Computer, or III, which is where criminal cases are entered, or at least OSCN. So if we've got somebody out there that's, got a terrible criminal history, at least the probation office and others can utilize it. That's going to be important. And so those are things that tribes can do to, smooth the system. A couple of other things that I had mentioned previously was the problem that law enforcement has encountered in trying to verify whether or not somebody's a tribal member or not. And, so what do you do? Okay, they say they're a tribal member, or you think they're a tribal member and they're not. I mean, you start calling every tribe in the country. Now, I think Creek Nation and Seminole Nation, all right, the Chickasaws, maybe the Cherokees now, their dispatch has lists of their members. Really, there needs to be a list of all tribal members, at least maybe in the state, some master list of some kind. Now, some of the tribes I can anticipate, and I've kind of heard through the grapevine, oh, well, we don't want everybody to know our lists. Well, that's going to be not a good thing if law enforcement can't verify who's a tribal member and who isn't, because people will say one thing to get out of, liability, or they'll say, I'm not an Indian, or they'll say, I am an Indian, depending on whatever it is that might be advantageous to them at the time. The other thing, database-wise, would be trying to at least report or somehow have a database of the tribal tags. I think almost every tribe in the state has tribal license plates or tribal tags. Is that information searchable on OLETs? I think some of the tribes that have compacted it is, but so it's not. So if you have law enforcement following somebody, trying to figure out, okay, who we have to search this vehicle. We have to get consent from the owner. Who's the owner? Well, you know, if we got a tribal tag from the Tonkawas, you know, what do you do? You might call the tribal police, but then, you know, if it's after hours, so there are database kind of things that can be done by the tribes and by attorneys that are advising the tribes that can avoid a situation where, you know, we have a newspaper report. Well, we couldn't figure this out. Nobody would answer. We don't know, you know, who's somebody's Indian or not. So those are things that we can take care of, and it's just a matter of developing a system of some kind.
Arvo made a very good point. I think it's a fantastic idea. In certain areas for the federal government, for example, on an army base, say like in Fort Sill, Oklahoma, it has exclusive federal jurisdiction. That means the state has no jurisdiction on Fort Sill, Oklahoma, because it's exclusive federal jurisdiction. So what happens is if a civilian, a spouse commits a crime, shoplifting, an assault, a DUI, they are prosecuted in federal court. But of course, there's no federal DUI statute. So what they do is they have what's called the Assimilative Crimes Act, where the federal government will assimilate the substantive law of the state, the elements of the offense and things like that, into federal court and handle a DUI. Now, they don't do the administrative aspect, but they do the substantive part. I think that might be one thing that a lot of tribes could do rather than rewriting an entire code and having to create the ABCs of every single possible state statute to mirror in the Creek Nation, Cherokee Nation, wherever. They could create what is called basically a tribal assimilative crimes act, where they could adopt some of the state laws into tribal court. And of course, again, that would be the substantive law, not the procedural aspect. So for example, and if you get a DUI on a military base at Fort Sill, they just look at the elements of offense. They don't look at whether or not the state, they complied with the certain effects of, you didn't wait for 10 minutes before you blew in the breathalyzer, things like that. That doesn't apply in federal court. It's just the substantive law. And a tribe could do the same thing. It could adopt some of the state statutes through an assimilative crimes act of sorts, and they could adopt it to their tribal code, and they would still have their own tribal court procedure. And that way they wouldn't have to rewrite everything from scratch. I know that's been discussed once before with one of the tribes I worked with. Of course, in the meantime, we've had COVID and other aspects, but that's one other area that tribes need to also consider. Arvo also talked about making things searchable, cases, you can find them. In Oklahoma, a lot of the state court cases are put on the Oklahoma Supreme Court Network, OSCN. You can find them. Federal courts, you can find it on PACER. I also know that some state courts use PACER as well. I think Mississippi uses PACER. A lot of the tribal courts need to think about a way to possibly make their cases searchable and where they can find them. I know the Choctaw Nation has a great database where you can log in and you can pull up all the cases for the Choctaw Nation, but not all the tribes have that. I know that's a little bit further down the road. That might be viewed as not really a must-have, but a nice-to-have. But it is necessary for the tribal courts to get that respect for everyone else, because, if Arvo Mikkonen or a public defender is handling a federal case and they need to know the criminal history, they need to find out if this person has been convicted anywhere, and is there anything that's going to affect them? How can they search it if they don't know if they've been arrested and convicted in the Creek Nation, Cherokee Nation, if they don't have a database to search? So I would encourage for tribal courts and tribal governments to start thinking about a way to make their court system, I'm not going to say more transparent, but maybe more accessible, especially with this age of electrons.
Yeah, absolutely. I think that's a good concept. Now, Dawn, I know that you've testified in a few district court cases. Could you talk a little bit about, if you can, where you testified and kind of what that process was? Because I know that there's some people that have logged on here and, they may be litigating cases now or in the future. And what kind of expert testimony have you given to district courts in trying to figure out reservation boundaries, or what happened, or, during the allotment negotiations, were there translators used, or was it in English, and how's that going to affect determining congressional intent and that kind of thing.
Well, for example, I had a young lady who was on a post-conviction, and she was being housed in the Department of Corrections in Potawatomi County. However, her conviction arose out of the historical Chickasaw Nation, and she was convicted, I believe, out of Garvin County. They're within the boundaries of the Chickasaw Nation. But so the post-conviction hearing was initially heard there in Potawatomi County. The judge was very much familiar with McGirt and the Creek Nation, but he was unfamiliar with the Chickasaw Nation. So I had to go through and I analyzed talked about the Treaty of Dancing Rabbit with the Choctaws and how it applied over to the Chickasaws, where they had their own treaty as well, how this individual was a member of the tribe. I made sure that was more or less trying to, train the judge or educate the judge. It's like, when they refer to a CDIB card, this is what it is. This is what it means. This is who issues it. But that's not all the evidence that you need. You want to have a tribal membership card, and this young lady had that as well. So, and we were making the record and admitting evidence. And of course, that's one of the state cases, Bossy. They remanded the case back down to the district court level to do judicial fact finding as to, do these documents actually exist? Let's get them in the record and then take it up on appeal as well. So a lot of the defense bar across the state has been very diligent about, we need your CDIB card. We need your, get your tribal membership card. Some attorneys are even getting letters from the tribe to say, yes, they are a member of the tribe as well. So a lot of these cases are being sent back to the district court just to supplement the record to show these are all the things that are there. On top of that, they've been admitting into the record the historical documents of the tribe, showing the documents coming from the tribe, when they had their reservation, how they received it, and what happened, and basically documenting. Here's everything showing that they received a reservation. We have no evidence where it was ever done away with. So, but the type of testimony I've been giving is explaining that to a judge or for whoever, just to educate them. We're at a stage now where most of the judges understand McGirt. There's a few rare counties where they don't know they still think it only applies to major crimes. But there's still a lot of education that's going on out there as to who can be an Indian. Just because you don't look Indian doesn't mean you're not Indian. Explaining that process, it's not based on race. It's not based on ethnicity. That a tribe is based on as a political government. We can explain all that to them as to why it's not based on, and I've gotten this from a judge, why should a Native American receive the benefit? Why not, someone who's African American? And I was like, it has nothing to do with race. So it's been that type of education with judges as well. They right now with the opinions that are popping up with the Chickasaw Nation that's been established, the Cherokee Nation, Choctaw Nation, and with the Seminoles, everyone seems to be kind of on board and things are moving along pretty good. But it's now coming down to those smaller cases like the traffic tickets and the municipal citations. And I think, I made a reference the other day to, as far as the municipality, up in Wisconsin, the Oneida Nation. They followed McGirt, and they found that that portion of the Oneida Nation was still a reservation. And that actually came from where a municipality was trying to impose its municipal code on a tribe. And that went up to the Seventh Circuit, and that came back saying, looking at McGirt, the Oneida Tribe's reservation is still intact. Therefore, the municipality cannot impose its law. So it's basically and I've been sending that Seventh Circuit case out to people saying, look, when they start talking about traffic tickets, parking tickets, you can even look at the Oneida Nation. They used McGirt and applied it to municipal statute. So it's been interesting to try to educate judges. I've also gotten, and I don't mean to speak out of turn on this, and I hope I'm not. I've even received calls from judges just to talk about McGirt, and of course I made it clear, they made it clear that I was not involved with any of their cases, and I didn't anticipate in testifying or being an attorney in that county. But I've had conversations with more than one judge just to talk about McGirt and how it applies and answer those judges' questions. And the judge, of course, the judges were like, we're supposed to know this, but we actually don't. So, and that was early on in the process. And I really I had to really appreciate that a lot of the judges were being very proactive and saying, I want to understand this. and how's this going to work later. The big question will be, where do we go from here?
Yeah, I think the other thing that several people have alluded to, I think it was the Miami Nation. I don't think there's a written opinion about the Miamas. Their boundaries were recognized, and kind of what practitioners need to do in presenting a case. And it's going to be very important, kind of like what Kirk said. Not every tribe is the same, and you can't just go to do legal research and find a case that's going to answer these questions. I mean, you've got to go back and for each tribe, figure out, okay, how was the reservation established? Was it established by a treaty? Was it established by an executive order? Was it established by a congressional act? And then the allotment process, what happened? Now, one of the things that Kirk had mentioned was there were negotiations. A lot of those are transcribed. If you go and do research, you can actually see the discussions between tribal leaders and the representatives. And it's going to be important to look at those disestablishment cases and to see what extent that analysis survives McGirt. And I had mentioned this before in some other cases, like Dakota versus District Court, which was involving the Sisseton and Wahpeton Reservation. They were trying to determine congressional intent by looking at newspaper articles and what somebody said, which seems to me kind of strange why, what somebody said in a newspaper in South Dakota would describe what the intent of Congress was. And it's just a very strange disconnect. But going back and looking at those cases, and I hope somebody's maybe working on a law review article or something, because all of those disestablishment cases, Matz versus Arnett, Solon versus Bartlett, Dakota versus District Court, there's a whole, Rosebud Sioux Tribe versus Knipe, most of them involving reservations up north. All of the cases involving the UNO Ute reservations. It's going to be important to go back and look at those to see to what extent to the canons of construction interpreting treaties apply. Okay, if you're dealing with the Cherokee Nation or the Creek Nation, I don't know if they were speaking English at the time, but if you look at what was going on in Western Oklahoma, there were translators involved. There's well documented instances of fraud, like with Lone Wolf versus Hitchcock, that's in there, and a lot of that information is out there, but you've got to dig it out. And practitioners really don't need to look so much at cases, but look at the original historical documents. And it's actually, to some of us, it's been very eye-opening to see some of the documents. And I know myself, I've looked at some of them, and even trying to figure out, like, for example, the Wichitas, Caddos, and Delawares, how did they end up there? There was an unratified agreement. Wasn't a treaty, wasn't a congressional act. It was an agreement that was unratified. And if you take a look at this map, I think a lot of you have this map back here. Take a look at that map. It'll tell you on each one of these little, there's a little notation there. It says the act of so-and-so in 1883 established this reservation. So that's going to be very important, the utilization of expert witnesses in doing history. You're not going to be able to just look up a case and find out, okay, here's the boundaries and this is what happened. So that's going to be very important. These cases are going to be a lot more historically based in going back and taking a look at documents like the Doomsday Report, some of these congressional reports. I found some things talking about the Osage Reservation, into the 1950s, talking about, well, and even the federal Code of Federal Regulations consistently refers to the Oto Reservation. So it's really going to be a challenge for, I think, some of those district judges to get enough information to be able to make proper rulings, and no matter which way it goes.
Okay, I'll jump in here for a moment. See if y'all have any other comments y'all want to make, or if I don't see any more questions on the chat.
Okay, there was one question here. I don't think it was answered. It says, what if my client is a member of an out-of-state tribe? Does it matter for an Oklahoma criminal charge? The answer would be no. What normally we would do to determine jurisdiction to see if somebody was Indian is if they're a member of a federally recognized tribe. They have to have some Indian blood, and they have to be a member of a tribe, and it could be a tribe from out of state. Generally, a federally recognized tribe, not a state recognized tribe. Okay, somebody asked if the person is an Indian, any tribe in the crime is an Indian country. It's tribal or federal, but not state. Generally, that would be true. The state would not have jurisdiction if it was an Indian within Indian country. Okay, this looks like somebody answered that.
And Arvo, somebody did ask again, and I think they asked about the class action on the fines and stuff. I'll try to pull up there is a class action in Okmulgee, and I'll find that case here in a second. But the one that's in federal courts is in there in the Northern District, and in fact, I thought I just had that name up, but I know that we exchanged it. So if I can find that email again, I'll post that in the comments on the names of those cases if they want to pull up the state case in Okmulgee or the case in the case in the Northern District of Oklahoma.
Okay.
Okay. So I was going to say there's a state case in Okmulgee County, and then there's a district court, Northern District Court case that they can refer to.
Okay, Stephanie, you've been referred to as a superstar moderator, which I would.
Well, thank you. I just try to make sure that I keep everything going for y'all, so y'all can just do the wonderful job of presenting. So
before you give the last question, I just want to thank, on behalf of the Indian Bar Association, I want to thank you, Stephanie. Thank our panelists. They've done a fantastic job. This is our second CLE in these strange times that we're in. I'm not going to say new normal, but that seems to be what it is. And again, welcome everybody to join the Indian Bar Association. We finally got our, took me a long time to figure out how to get that Eventbrite working, but it seems to be working, and we're processing things. So we had some really talented people here, and I just want to thank all of you that have tuned in and participated, and particularly our panelists who volunteered to take some time out of their schedule to put this together. Let me see, there's another question just came up, maybe.
Let's see. It looks like William Norman posted this afternoon, the U.S. Supreme Court granted review in United States versus Cooley, and the question presented is whether the lower courts erred in suppressing evidence on the theory that a police officer of an Indian tribe lacked authority to properly temporarily detain and search respondent and non-Indian on a public right-of-way within a reservation based on a potential violation of state or federal law.
This is why cross-deputization, because if they were cross-deputized, this would not come up. It's and I guess that's just that's concerning, because it's kind of a long, difficult process. I hate to say it, but it really isn't as bad as it sounds. And it really, I think this is one particularly unique cause that we as attorneys can emphasize with our clients or people that we work with, because a lot of times people don't understand it. It's like, that's just a bunch of mumbo jumbo paperwork, but it's very, very important. And usually when attorneys are pushing along the need to be cross-deputized, the need to, cross all the T's and dot all the I's, it works out well, and people that have done this a long time ago, people like, Truman Carter in Pottawatomie County, who really, taken up the cause and said, tribal leaders, we need to do this.
Mm-hmm.
We need to work together. We need to get these things in place. We need to have our ducks in a row, because at some point in time, it's going to be an issue. And obviously now it is.
Yeah. Okay, well, I appreciate everybody staying till the end to listen. I know you're here because you want to hear your word. So the last word is Choctaw. And if you'll put down all 4 words, your name, your bar number, and send it to Oklahoma Indian Bar Association at yahoo.com, then we will get those sent. If you will put your name, your bar number, and the 4 words all in one email together, it will expedite our efforts in getting the credit awarded properly. So thank you very much for everybody hanging in there, and thank you to Bobby Don and Arvo and Stacy and Kirk and Brian Candelaria for running background for us. Okay, thanks a lot, everybody.
Thank you.
Thank you.